Give all the memos. Give all the memos.
Hey, give me a memo.
Yes, please, give. Give all the memos. Where you were on the last week, nobody gave.
Maybe I to mention my law. One urgent matter that is.
Please pass on the memo. Please.
Mentioned from the list. Item 50 this may be taken up after long on first because admission letter. The others have the letter my law.
Let us see.
May not reach, that's why I mentioned my.
Cannot.
Cannot.
Let us see.
Yes.
Cannot be taken up.
No, may be taken. May be taken after.
Your Lordship, my item is 49 and I haven't prepared because of my bag. If I need, it's a voluminous case, I need 2-3 weeks time with Your Lordship.
Let us see.
My lord, item 50, madam. The state has a file canter. I need to revision why I will file 2 weeks time.
Miller's item number 24. Here's a great one. It could be senior advocate Mr. Janaki was supposed to address your seat. Yesterday only the message came to Tally. And Mr. Mahathi has been approached yesterday. So I
Yes. Don't worry.
whether we listed.
Let us see.
Your Lordship, may I have the leave to mention regard to item number 16, Your Lordship, of today's list. Your Lordship, I am for the respondent, Your Lordship. The state is the appellant, Your Lordship. In this matter, the councils are traveling from Kolkata, Your Lordship. There has been some predicament, Your Lordship. I see for an
You are here, let it be called. We'll see to it.
I am ready.
Just call the list.
Item number 1.
Pass on the memo.
Yes. Item 1.
From my lord, this is the file where the instruction of road work. Construction of road work, which was stalled because of the pendants of yes, file earlier, my lord. Please.
6497.
The road for essential.
Why it is not?
Lordship, this is connected to the second matter, Your Lordship.
Yes.
The PIA pending, for the pendings of this PIA, Your Lordship, without progressing the second matter.
Is there any interim order?
No.
No, Your Lordship.
Then why it is not progressing?
Lordship,
If there is no impediment,
Lordship, there were a lot of instructions that were told on our part to be produced before court, Your Lordship. So the first, the R&B department did file a counter affidavit. Then an affidavit was filed by the collector for the Your Lordship. Then another by the SCST department, Your Lordship. In all these affidavits, it's been found out that the petitioners are encroachers of the common land. Whatever has been deed reserved, diverted from the forest land has been done. So by proper law, Your Lordship, the forest department has diverted.
these are the counter writ petition filed by the other side, second one.
Your Lordship, that was the initial PIL, Your Lordship. Yes. And then.
So it's a counter case. They wanted the construction. They wanted to stop the construction. That is only.
The lands, they were going to encroach upon the lands of these ST tribe members, and these lands are belong to a Gram Panchayat, and and lot of buildings and all their houses would be demolished or acquired by the state government because of the realignment.
So that is what you have to do it. If it is a road which you feel is it will subserve the public at large or will give, then you'll have to take steps. If it encroaches upon any land, then what is the law permissible? You have to, then you'll have to accept it. Otherwise, that cannot be done. And who is for the second petition? Yes, why you want? They will take the law there.
Twice the
CDP, the comprehensive development plan was modified. First in 2010, which has, we are not challenging that. 2017, it has been modified, and modified comprehensive development plan was notified in Gazette. Now they are tinkering that modified comprehensive development without resorting to the statutory provision of law.
What is,
If government violates the law, then
no, obviously you have a right that if your right is infringed,
we are all Adivasi people. Since 3 generations, we are staying in that first stretch of land. That also that belongs to the Gram Panchayat. The dividing line is the road, and now they are transgressing into the Gram Panchayat area and urban road.
Can-
that
so you want that no development should
No,
take
no,
place
sir.
within the village or in a
I'm
Gram
not standing-
Panchayat area, they will remain in
No,
a
no, sir.
rudimentary
I'm
age.
not at all standing in the way of development or realignment.
So,
As per law, they may be aligned because of the geometric flaw there.
so if they want to provide this infrastructure facility to the various villages nearby, and for that, if they wanted to just make a little digression, then can you,
For the
if
purpose-
they have to take the law,
They have
in-
to take the.
no difficulty that they will not take the law in their or apply the law. But
But the diversion laws, the realignment is for the purpose of protecting one enclosed area by one influential person. One influential person has been allotted with a piece of land, and beside his boundary, the original CDP, the road was aligned. Now, and here
what is the
enforced-
purpose? What is the purpose of alignment? Realignment. Let us see. Not
Realignment,
alignment. Realignment. What is the purpose? There must be some
There's a
objective.
geometric flaw. Geometric flaw in geometric
Have they
parameters.
disclosed in their affidavit that why it is
That's it. Some engineering department was.
let us
concerned.
see. Which one? Paragraph 4 of which affidavit? By opposite parties number 689 or by magistrate what?
6, 8, 9 and 10.
Yes.
Your Lordship, we have said the reason is, Lordship, the last four paragraph, the last 4 lines, Your Lordship, to the first paragraph. In the tentative master plan of BDA, the earmarked road alignment was encountering a sharp curve that would have been risky for the navigation of vehicles and commuters and prone to accidents. Besides that, a number of important structures would have to be demolished if the road is constructed as per the tentative earmarked alignment. From the engineering point of view and road safety parameters, it was felt expedient to modify the alignment basing on geometric design parameters such as minimum radius of curve, that is 200 meter, and better design speed, that is 50 km per hour, in conformity with the Indian Road Congress RC norms. In the modified plan of the alignment of the road, there would be demolition of bare minimum important number of structures, land would not be affected. Keeping in view of these parameters and the road safety angles, the road alignment was modified for public convenience to provide better connectivity to the expanding city space, Your Lordship. And then, Your Lordship, the next paragraph also, Your Lordship.
Or they have dealt with have they filed rejoinder?
No.
No.
That's it. What happened? Engineering department was part of consultation as per the ODI. My Lord, acting Chief Justice raised one question. If engineering department was consulted by that time when the CDP was modified, then how the further engineering department says that there is sharp curve, because sharp curve is created by the encroachment. But they cannot tinker with the modified comprehensive plan.
You can't come up and then say everything that what you do, what you know. Are you an engineer? Are you an expert? If there is an expert, if you say that I can constitute a particular committee of the experts, engineers, if they submit the report and say that this curve, that is because what I gathered from here is that this sharp curve, because
Sharp
the
curve.
minimum sharp curve, according to him, if the speed of the vehicles is to be maintained as 50 kilometers per hour, then there is a chance of any accident. There is a chance of say incident that may happen and cause the life and death of many. So they said that yes, it was subsequently it was noticed, and thereafter they were. If you want, because that is the reason. You are citing a reason which is neither here nor there.
That's it. If they are realigning, there is a provision that either the encroachment.
So
or
they
the-
will
Provision of law.
consider.
The provision of law. As
So
per
they
the
will
Act,
take
have to
care.
do.
They can't do it without the recourse to law.
But
They cannot do it, but you can't stand in the way. If they say that this is what are the practical, sir, when you make a construction, there is a site plan
Right.
sanctioned by the authority,
Right.
but at the time of a construction, there are certain things felt and which need some kind of a modifications
What-
just to avoid. Can we stand in the way?
No.
Because these are all the experts' opinion.
That's it. I'm at one with my lords. But one thing, if one encroachment can be removed, then the entire that cause can.
Sir,
be.
how can you, are you an expert? I'm asking you, sir. You are a layman. We are sitting here and saying that it can be done. We don't have an expertise
That's it.
so far as the engineering part is concerned.
That's it.
You do not know that what will happen. They have an experience in this regard. There are literatures on that. There is a set, the standards which are to be followed. How can you impose as a layman that you encroach only one and then make a sharp? How can you do it?
That's it. By,
Can we also?
by the realignment, 450 families are going to be displaced. 450 families will be displaced. Please, you'll get your question. 450 families in Grampon living in Grampon.
What you say?
I am for Bhubaneswar Development Authority.
You are taking all these initiatives.
No initiative in matters to that department, works department. They have to undertake construction. We have to only prepare that plan.
Who has sanctioned the road?
We have a plan. We have to prepare. They have to.
So you are really a requisitioning authority.
No, madam.
You wanted a road,
No, madam.
and thereafter the PWD will execute the work.
The utility matter. So far as the development, each of Odisha is concerned, there is a Development Authority Act. Because Development Authority Act is concerned, we have to prepare a comprehensive development plan concerning the areas coming within the purview of the Development Authority. Here, while preparing those, these were all prepared by the IIT. Because it is called Vision 2030.
Sir, probably
They are
you could not understand my concern.
I must.
You have not. The first step which is taken in this regard is a policy decision
Yes,
by
we
an
take
authority for a construction of a road.
Right, madam.
Who has taken a policy decision?
There, my lord,
You,
yes, ma'am.
as a
We have
development
taken-
authority,
We have
you have
accorded
taken.
for
Now,
approved by the
that
company of-
once you have taken,
Yes,
now so far as the execution part is concerned, it has to be done by a PWD or whatever. They have to consult the
Yes.
many engineers, whatever
Yes.
that is within
Yes.
their domain, you
Yes,
can't.
sir. Very well.
You simply wanted that this is my policy decision, we want
Yes,
the
sir.
road
That
to
is
be
done.
constructed.
That has been done.
Right. So this is why have you ever realized that there will be a lot of displacement to be undertaken in this regard?
May I submit one by minutes? My learned friend says that lot of displacement of undertaken. They are the encroachers. They must claim that they will be evicted. Other party they say that they will. But when we are laying a road miners, and particularly when it is related to miners, technical part miners, then miners the encroachment, eviction of encroachment should not stand in the way. That is my humble submission. Sometimes it requires minor. Suppose miners I am undertaking construction. During construction, I face some problem. That is what we are changing the alignment and all these things. And that is what the law permits a compounding concept. Here in this case, we found that yes, their contentions are genuine. That is what we recommended to realignment. Under exercising power under section 14 of the Development Authority Act. That is what government approved. Thereafter, they have stated that they have undertaken construction.
Yes, yes.
Now you encroachers have come up not only plea that yes, you are going to be evicted or there at their instance you are going to be evicted. You say that your right to be protected because you will stay there in that land.
And your lordship, their concern about
And in
the
the
forest dwellers, that has also been dealt with by the SC and ST department. And they have held that their petitions have been rejected and they've been held to be encroachers, Your Lordship, because they have come and settled there after 2005, Your Lordship.
SC department has filed any
Yes, Your
counter?
Lordship, they have filed an affidavit.
They have filed separately a counter.
Yes, yes, sir.
The counter copy has not been served on me with repeated request. I requested that my lord ex-chief justice has directed.
What is a past is a past. Live in the
Whether
present.
they are bona fide,
Live
they are
in the
bona fide
present,
tested.
sir. Live in the present.
They are bona fide
We are
tested.
more.
Now, earlier order stands.
Bona fide and malafide is a two concepts, sir. If the particular authority who has the jurisdiction to decide a particular cause, if they have found that your encroachment is not protected by any law, because you were found to have encroached after 2005.
No, that's wrong.
Yes.
Have you challenged that? I'm asking
The
you.
copy has not been served on me.
And two of the
That was.
petitions are also there, Your Lordship. Two of the petitions.
Have you challenged this order?
No copy has been served inside of.
Oh, sir, this is what is the copy here counter. I am talking about that proceeding before the SCST department. I'm talking about that proceeding where some of you were already there.
Yeah.
Have you challenged that order? It was passed in your presence.
Could not make out the minutes.
Could
We are
not
not
make out. Then I think
That is mentioned in
in your language, if you say.
Mr. Patnaik,
Yes,
para 6 of the counter we are submitted.
yes, Your Lordship.
All these 238 numbers of claims have
Yes,
been rejected by district level committee on forest rights side.
yes, Your Lordship.
That's what.
Yes, and two of those petitioners here, petition number 2 and 3,
They
Sukur
were-
Mansa
they
and
were
Narayan
there.
Mansa, they were there.
They were there.
Yes.
What you were doing?
They are never noticed.
Harish?
Neither they were consulted. No officer from the SCST department either visited or asked anything to them. I have taken specific.
It is in the
instruction
year
to that
2005.
effect.
It is in the year 2005.
2005. We are living there
So
for 3
when was it
generations.
rejected?
I can have voter. I can.
Madam, when was it rejected?
Yes, Your Lordship.
When was it got rejected?
It was rejected in the year 2012, Your Lordship.
Got.
12.
No, there was a event,
The direction is
Paragraph
2025.
Grammar Sabha was also
It is clearly
held,
mentioned,
Your
paragraph
Lordship,
6
in that
of that counter.
panchayat.
So
And
date
it was held in
has not been
2006.
mentioned.
But
Date of rejection is not
date of
mentioned.
rejection
I'm not
also
finding.
mentioned. But it is in paragraph 6, bottom 4 line, my lord. Will kindly speak. Community. I'm just pressing, my lord. That the Grammar Sabha resolution has been passed,
Passed,
the
yeah.
people were present, the serpents were present, everybody was present. And after that only, they have also the realignment of the question raising that it is not in consonance with the VDA, CDP, comprehensive development plan. Your Lordship may kindly see the gadget notification C/10, page 11, the R&B counter.
Yes,
That he
Your
has
Lordship.
not
There also
annexed in the
please say.
counter, the writ application, they have annexed in the counter application.
Para
Six,
6 also we have held.
Kindly, my lord. Page 11, my lord.
6, 7, 8
But
and 9.
C.
Yes,
Yes.
para 6, Your Lordship,
C by
which might
10.
read out.
Counter affidavit C/10 of
10.
page 11 of the R&B, my lord. 6, 8, 9. But the gazette notification, they are annexed. The VDA gazette notification, which villages are included in the VDA, CDP, comprehensive development plan. But it is counter affidavit of 6, 8, 9 and 10. Paragraph, I am pressing the annex there.
Call number.
Page 11. Gazette notification. That the village Jagannath Prasad is there included, and road is coming over the village Jagannath Prasad. Chunukuri is a self-created basti, there is no revenue village, and alleged by the petitioner. Jagannath Prasad is included in serial number 4 in the gadget notification. A road is coming over that. And it is a comprehensive development plan 2018 gadget notification. He also prayed in paragraph E of the prayer that the road shall be constructed as per annexure 1. This is the annexure 1 gadget notification. And present realignment also in consonance with this gadget.
Yes, Lord.
No, that's
Comprehensive development plan, that is the comparative of collector revenue. He is the head of the revenue authority in the district. Collector comparative to kindly see opinion number 13, madam. Clearly mentioned there is clarity is there in collector comparative. If your lordship will permit me, I will place the collector order. You can clearly mention paragraph 6 it start. Mother, counter affidavit of collector, OP number 30, dated 16/8/24. They are filed. Paragraph 4 is the start, madam. May I place before your lordship phase 2 of the counter affidavit collector. Is the head of the district revenue authority. But that in reply to the government made in paragraph 1 of the writ petition, it is submitted that construction of road project, namely construction of 200 feet road from Institute of Mathematics to Ekamura Kanan via Infocity from RD Road, so and so, left parallel road is being undertaken by the superintending engineer R&B Division 3, Bhubaneswar in Mauja, Pathargadia, Sundarpur, Jagannath Prasad, and Chandrasekhar under Bhubaneswar Tahsil. That gadget I have shown your lordship. Jagannath Prasad was there. And they are claiming Jagannath Prasad, the petitioner case. In the Tahsil, in the larger public interest to ease the traffic congestion in the existing road in and around Bhubaneswar city, it is further submitted that the construction has been made over the private land which have been acquired or purchased from the landowner following the due provision of 2013 Land Acquisition Act. And no such alleged eviction or demolition of houses of the petitioner have made by these opposite parties. Thereafter, lordship come to the paragraph 6. That in reply to the argument so and so, it is submitted that the petitioner belongs to scheduled tribe Adivasi who are residing over the government land in Chunukoli Basti. It is a self-created Basti. It is not a village. It is wrong separation of material facts here stated in the writ application. The village, panchayat, all these are coming. Chunukoli Basti coming under the Mauja Jagannath Prasad and gadget notification of the comprehensive development plan which I have shown to your lordship. Jagannath Prasad is included in serial number 4. What is the wrong? It is in consonance with this notification, CDP plan published by the gadget notification by BDA in 2018. And this realignment is in consonance, there is no wrong. And your lordship may kindly see the paragraph 7 also I am placing. In connection with the construction of the above proposed road, the original comprehensive development plan of BDA with approval of government was notified in the extraordinary issue of gadget notification 8 April 2010. Subsequently, the CDP has been not modified by the BDA Bhubaneswar following due procedure as laid down under section 14 of the ODI 1982. And the modified CDP has been notified as a modified CDP 2 by 2017 and published in extraordinary gadget issue on 14 May 2018, which I have shown to your lordship, that gadget notification. And in the modified CDP, the road arrangement in question has been modified following due procedure of law. What is the wrong? And in your lordship may kindly see para 9 also next para. Here clearly mention everything. That in reply to government so and so, it is submitted that for construction of said proposed road project, total 1.536 decibel of forest land is being used, the details of which is given as under. Your lordship may kindly see the table. Jagannath Prasad only 4 decibel land. Forest diversion proposal also he has mentioned that sanctioned by the DFO Chandaka. And that also mentioned in the counter. It is submitted that as per the original comprehensive development plan of BDA published in the year 2010, total 2.203 decibel of land, 2 acre land was first land, was proposed for the set. In the revised CDP, the area of forest land has been reduced to 1.536. Now the realignment which is questioning by the petitioner. The forest land is 1 point. Earlier it was 2 acres, so more, it is mentioned. Out of which only 4 decibel of forest land in respect of Mauja Jagannath Prasad. So far as the present PIL is concerned. as alleged by the petitioner, and only 4 decimal forest land, and there is forest diversion proposal also annexed in the document, counter petition, your lordship may see page 7 of the counter. That is the forest department, DFO sanction,
A by 13.
that is A by 13 counter.
They have said also in paragraph 11
Yes,
that
Your
in
Lordship.
the event if it is found
Yeah.
that it is enclosed by somebody, then the eviction of an illegal encroacher, if needed, will be done following the due process.
Due
of
process
law.
law. What is the wrong matter? And they have enclosed the government land, and subsequently they have enclosed our private land also. I am appearing for the private opposite party. We have filed a civil suit. We got the decree. Execution is within. They are not allowing any private owner to enter the land because they are claiming that we are Adivasi and the forest rights, no forest rights, because the counter in the ST department said after December.
Your land, which they have encroached upon, was recorded as
Yes, trespasser. I have filed the judgment also.
recorded the nature of the land.
Barbari. Isom is Barbari, homestead land, conversion.
Where is the forest land?
But forest land,
They're talking. If the nature of the land in the record of land is shown as the homestead land,
yes.
then it ruled out that the land belongs to a forest. That shows so.
No, no. Our picture.
Sorry, I'm talking in your favor and you say no.
But
Our interesting.
our.
I have
says no.
three lines to suffice, lordship.
Wait. I'm sorry, my lord. I mean, sorry.
I have 3 lines to suffice, lordship.
In order
Wait,
to
wait.
clarify ourselves, I know this, just making your argument straight. If our is showing it as homestead, where is the question of any other person claiming it to be a reserved land or
Forest.
forest land?
Yes.
You say no.
No, my lord, because I'm not saying, so far as this particular 4 decimal land is only the forest land, as per the counter.
You are not claiming on this 4 decimal of land.
No.
It is outside the 4 decimal of land. Then why
We
you
have
are,
nothing to.
why you are? This
Because
4
our
decimal
land is-
that particular Jagannath Prasad
Prasad.
does not come within that particular. So no, why you bother?
But the road is, the proposed road will construct over the private land.
Or so they
That
say,
map is there.
they have this paragraph is restricted to a forest.
Yes, Your Lordship.
They say that initially it was 2 point something, 2 acres and all. Now they have reduced to 1.5 acres.
One.
And out of which only 4 decimal of land of Jagannath Prasad is used, which is a forest land, that's all.
That is conversion.
If they have included this road passes over that particular, the private land, then they will take care of the interest of the land. They say that we will definitely acquire.
I put the law.
Whatever compensation,
Yeah.
whatever is there, everything will be taken care of.
Where no bills to that.
Sir,
That is
3
what-
Yes,
lines,
ma'am.
3 lines to suffice my argument. One, the private ownership of forest land. That was initially
How
forest.
can you, sir, how can you say,
In the-
sir, the law, you have to talk law. You are a officer of the court. What is, I know, so far as the Court of Right is concerned, it is not a document of title, it is not a document of title. But the law is that it has a stronger presumptive value of its correctness. What it says so is if the nature of the land is recorded as our home state. Unless that particular entry in the record of right is changed, or the alteration or modification is done. Nobody can say that the nature of the land is something else. There is a presumptive. You have to prove that this particular entry is wrong, erroneous, before the authority. So you cannot now say, because he says my land is recorded as homestead. You are saying, no, this is a forest land. That's it. Can you say without any initiation of the proceeding or without any order?
I have not asked you to that respect, lordship. What happened, why they have mentioned that original CDP, modified CDP has no mention of that particular patch of land. Because it was not within that, they are now transgressing into Gram Panchayat area. For that reason, it was not in.
Gram Panchayat, sir, the Gram Panchayat, they say there was already a Gram Sabha which was there. And
It is
in
earlier.
presence of all the villagers, in presence of the Sarpanch of that or a Pradhan, I do not know what. Tamil Nadu is Sarpanch. So in that event, it is decided, yes, there is no
One
difficulty.
impression given to the
can.
court, that's it, one impression was given to the court that they are not tinkering with the modified plan, but they are tinkering the modified. It was prior to the modified plan.
What do you
There is
mean
a-
by tinkering? Just tell me, if it appears that twice this particular plan, there has been a realignment,
Real. It is for the
What
third
is it?
time. It is for third time.
twice. Right? Is the
Twice,
10 and 8.
10 and 18.
Twice, that's
Now
what I'm
they-
saying. Realignment, when I use the word, first was an alignment. When you modify it, it is a realignment. So twice it was realignment. I
After
think I'm very
that,
choosy in my expression.
after that, Lordship, now in 2023, after the gazette notification, they are now realigning it into the campus.
Have you
This is
got
for the
any,
third time.
have you got anything coming out that they are in 2023 realignment? Because
That I'm
they
challenging.
have not. They
I'm
are-
challenging my
Where
annex.
is that?
Lordship, annex
Because
two.
earlier all the realignment was done in accordance with law, duly notified in the extraordinary gazette of the Orissa. And therefore, under section 14 of the BDA,
Yeah.
they have done it.
Comply.
They have done it. Now, you have to say whether this was a excessive authority which they have used. They have not followed what, they have not followed this. You'll have to show the law.
That after the gazette notification, what?
Because the last
They are now-
realignment is of 2018.
Yes, the realignment now it is also being.
I do not know.
That-
2023 shows, where is the 2023
23
for the realignment? Shows,
That is my allegation.
shows.
That is
Allegation
my
you
allegation.
don't do. Shows the document.
The document, Allah said.
Please.
At page 20 is the original modified plan.
I am talking about 23. I have
20,
seen
yes.
the original modified plan
That's it. That is page 22
of
of my REIT application.
writ application. Which annexure?
Annexure 2 series members.
Yes. This is, I think, is a comprehensive, we call it as a Mauja plan. What do you call it here?
That's it. It's a.
You call it here, sure.
Annexure 1 is the modified plan. Annexure 1 is the modified plan.
That is of 2017.
17.
That was officially published in the Gazette in 2018.
Yes.
C10.
Yes.
C10.
That I'm referring to. That I'm referring to. That modified plan is thing.
You are talking in the 2023, sir.
Yes.
Where is that?
It was
Don't-
one
don't-
term. It was one term.
No.
I'm
No,
just
no.
asking, he say the tinkering with. So I just want to know what is the meaning of the word tinkering.
That's it. Page 22.
Please, I am looking at page 22.
That's it.
Shows.
This is the
Shows.
letter written
Yes,
by the engineering chief engineer
yes,
to the chief construction engineer.
yes.
And page 21, the dotted lines, which is deviating from the original annexure 1,
What?
the modified plan.
Where is the modified plan?
Modified plan is
Is of
page 20
2018.
page 22 is the modified plan.
It is not a modified plan, sir.
Letter.
That's
No,
a
no.
letter showing that the revised alignment plan submitted
No,
by
that's it. Page
is
20.
is
Page
hereby
20.
approved.
Page 20, Lordship. That is modified plan. Page
It
20
was
is a map.
where
The colored map, Lordship. This one.
please show us that where is that? Where is the sanction which is accorded? Show us the date of that sanction, because I find from right hand side bottom, it is a comprehensive development plan of 2017.
Yes.
So that means they have already published it in 2018, C10.
That's it.
So if they say that it was all done in accordance with the law taking care of this. So you are talking about something which is done. If that 2017, they have not taken any decision, And in 23, they have approved this plan. That does not mean there's a new plan or new realignment. It is really the approval of that 2017 modified realignment.
No, Lordship, sir, it's the plan, the dotted line I said. It's the transgression into Gram Panchayat area. Otherwise, it was,
How you are affected, sir, if your sarpanch and all the villagers, they have agreed
to the
on
earlier road.
this, then
to the
what
earlier-
what remains?
earlier road.
Recent resolution.
To the earlier road, we are agreed.
23.
To the earlier road, which was notified in 2018, the Gram Sabha was called, everything was done as per law. The grievance petitions were heard and disposed of, and that was the original plan, which was modified in 2017.
What is the difference between the first realignment and the second realignment? What is the
First realignment was just the reverse side. It was
no? I'm talking about the Gram Panchayat land.
Gram Panchayat, madam.
In that,
Yes.
raising that issue.
Yes, this
So let
Jagannath
us see
Prasad.
first realignment
Yes,
and second realignment, how it makes a difference.
I'm explaining your.
Yes, please.
Earlier, Jagannath Prasad, the village was not there. Sundarpur and Jagannath Prasad village was not there.
Not there.
Earlier.
In
2010,
Initial
initial.
alignment
Yes.
map, then
Then it was
first
modified.
realignment.
First was the 2010, that IIT, what they have done.
There,
Thereafter, taking into consideration the expansion of Bhubaneswar, then the BDA modified 2017, that was published in the Gazette.
no, there was two. Prior to 2017, there was another realignment.
No. Not realignment, initial alignment was basing upon 2010. Then it was the CDP
Then
was
Jagannath Prasad was not in.
not there, not there.
Very good. Then the first, that means I am wrong, not two realignment, it is the one on that.
Yes, sir.
Realignment, is it correct?
Yes,
Yes.
yes, ma'am.
So in the year 2017, when you make a realignment, then how many Gram Panchayat land is included with?
Yes, yes. But that C by 10 annexes.
That is C by 10 point, you have said point
Then
004.
counter affidavit of
That was in relation to
that was section 14 exercised by the BDA.
foreign.
C by 10 minutes, this is the letter of the notification.
Comprehensive
Gazette
development
notification.
plan, that is Bhubaneswar, it is coming within the Bhubaneswar
Page
development
55,
authority.
page 55.
Only what we wanted to have was it's flagging an issue when we are delivering a judgment, we must say that what is what.
Your Lordship, we have stated in a
Just,
paragraph 9.
just when you make a realignment.
Yes, yes.
How many land?
That,
Forget about the forest land. It does not belong to Gram Panchayat.
We have stated
Now
in
you are looking
paragraph
at
9
again.
of 6, 7, 8 and 9, counter affidavit to opposite parties.
Paragraph 9.
9, Your Lordship.
Yes.
You stated that it is somebody submitted that the modified alignment of the road runs through the geographical limits of the Bhubaneswar Municipal Corporation. As such, the arguments of the petitioner that the modified road alignment runs into Grama Panchayat area is baseless and not correct.
Then why there was a Gram Sabha there? If it does not really come within the Gram Panchayat,
But they were,
then why the Gram Sabha was held?
Your Lordship, when the Gram Sabha was held, because these people were exercising that we are inhabitants of this place and we are settled here, we are forest dwellers.
So if it comes under the municipal corporation, then it ruled out any panchayat area to be included within the municipal corporation. It is no longer a panchayat area.
No, no.
That is no longer a panchayat area. Why Gram Sabha?
Gram
Ram
Sabha,
Sabha is for the purpose of forest.
forest rights.
That is
That is what a clarification I
Yes,
require.
but that is for the purpose of forest.
Forest.
Then Jagannath Prasad is a village.
Yes, it is included in the BDA, Bhubaneswar Development Authority.
BDA is one and the BMC is another.
Yes. Your
BMC is the municipal
I'm
corporation.
Municipal Corporation Limit, yes, and BDA is
Development
Development Authority.
Once it is in the municipal corporation area, then means it is carved out from a panchayat.
Yes.
So they will be governed by a municipal corporation. So there will not be any sarpanch.
No.
There cannot be any
Yes,
Gram
yes.
Sabha.
there cannot be any Gram Panchayat.
Right, correct. It is for the purpose of forest only, that regulation. Gram Sabha is for the purpose of diversion of forest.
And forest land was outside the BMC area.
Yes,
But-
Lordship.
Yes.
Yes.
Lordship, one impression was given that they are not,
Are
they
you
are
coming-
acting as
are you
per
coming under
the,
the-
one clarification, Lordship.
I am asking yourself, are you coming under the Bhubaneswar municipal corp?
No,
Can you show me the receipt of any tax or something of that area? Who issued or collects the revenue land tax? Everybody who is holding a property has to pay a
demonstrate
tax.
one thing,
Either it
that
is a
we are the
municipal tax
voters of
or
Ambharwal
it is
Gram
something
Panchayat.
else. Sure.
We are the voters of
I am
Ambharwal.
asking.
Mr. Mansi, perfect. What is it ready? Please answer. What is it ready? Please answer.
We received.
You are not comprehending the question very which melody is posing. Please answer
Holding
that.
tax, we are not landowners. So holding tax, that no question
Even
of
if
paying
we
the
are
holding tax.
landowner, we are not paying any rent or anything to the municipality. We are
No,
simply
it's not a
paying.
rent. It's a municipal tax. I do
Municipal
not-
holding tax.
Holding tax.
Holding tax. We call it a municipal tax. So that's why are you paying?
We are not
No.
coming under
Why
municipality.
you are not collecting?
Only, if
Ground rent to parcel.
Awesome.
The revenue that is called rent receipt khajana. In
Khajana.
India it is called
No,
khajana.
this word, Adina, I am
That
well aware of.
has come from that
I am well aware of, because it all originates from.
from the Bengal side.
Yes, yes, Your Lordship.
I am aware of a khazna receipt and what is that?
holding tax.
When it comes within the municipal
So
corporation.
then it is
Madam,
holding tax is
concept,
represented.
Then
Holding
the
tax
tax
concept is,
territory of the municipal corporation.
if there is a
Then
dwelling
whoever
house, then
comes,
only holding
They,
tax.
they are liable under the Kolkata Municipal Corporation.
right.
They are liable to pay tax.
Holding
It's
tax.
called a
Holding tax.
holding, we call it a building tax.
Building tax. Now
If
here
there
it
is
is
a
called
building
holding
house,
tax.
It's a
What
holding
is the
tax.
building?
So somebody has to pay holding tax.
Subject to condition if they constructed a house.
If there is a dwelling house,
No.
Otherwise, no.
not, if there is a dwelling house, then we have to pay holding.
I think they have maintained the mutation records as well immediately after the land is transferred to the BMC. From the panchayat.
No.
But if there, my lord, so far that holding tax is concerned, they will include it. So far,
They
they
must be maintaining
land revenue, my lord,
of the owners of the respective lands,
that is being maintained by council.
which was initially under the panchayat, now integrated into the municipal corporation. Municipal corporation must have maintained the register.
Register in the sense, my lord, the demarcation of the area.
Then we have to obtain the approval of the building plan from BDA. That is the Bhubaneswar Development Authority expansion. If even Jatni is another municipality, it is far away to 20 kilometers from Bhubaneswar, it is BDA is coming.
Yeah, that is what I understand from the constitution perspective,
Alright.
that there are three areas within that particular state for the purpose of collection of land revenues and the development. One is the panchayat is also recognized where the lands are or the particular areas are within the panchayat area. Then the panchayat collects certain revenues or certain things, they are responsible for everything. Then there is a municipality area. Which the state from where I come, I
Right,
just
that's-
municipality area. which is not in the panchayat, but not a municipal corporation, but a municipality
area.
where the municipality is created, they maintain.
Packet land, they are not
And-
collecting anything.
Simplicity.
I'm not talking about, I am conscious. And then the municipal corporation, there are three. And there are three separate acts.
Yes.
One is the municipal act, one is the panchayat act, and another is the municipal corporation.
Yeah.
So these are the three divisions which I know about it.
Right.
Now, once it comes within the municipal corporation, say it may be a municipality area, it may be a panchayat area. Because once the urban, I think agglomerations or there is the expansion of the urban area. Then it's within itself the municipality area as well as the panchayat. The moment it is integrated, no doubt, because initially the record was maintained by the Tehsildar. But then the entire record that gets transferred to the municipal corporation. Because of their territorial jurisdiction, so they maintain that which part of the land or how much land, where it is situated, which has now come under this, is owned by whom. So the ownership is also maintained by themselves. Based upon that, we call it a porcha.
Yes.
What is the term here?
Yeah.
The porch.
Yes.
So
Very
there is a
distinct
porcha
called purchase.
showing the Hajar. Now my brother, what he says is that suppose if the land is given to a development authority for the development, then this is the setting up of a township. So they allot the land, whatever, on a lease basis. It may be a long-term lease, it may be a short-term lease. So you are a lessee, but the ownership remains with the development authority. So they may charge you a ground rent with a right to make a constructions. So the ground rent is collected by them. Once you make a building or a construction, then the municipal corporation will charge you a holding tax or a building tax as you call it, which I understood.
Correct.
It's a bit, little
That is
bit
the question.
question here in also in this case, my lord.
Here,
What happened?
here, what is happening, my lord? The moment we will submit the plan for approval, from that date, they will charge for the ground rent.
Everywhere, sir, this is not a very new thing which you are telling.
Otherwise,
Sir, the moment they sanction the building plan, whether you construct or not construct, they will go on charging that. That is what very common thing, sir.
my lord.
It's a very common thing.
May I minutes, just to.
So I understood the
Yes,
land
Yes,
management
my
here.
lord, here,
Correct.
slightest clarification is required by us, slightest clarification. Or by your own experience, limited experience, my lord. Here in this case, what happens?
Yes.
Here in this case, what happens, members? So far, the municipal corporation is concerned. Once area is included, a municipality or a gram panchayat included within municipal corporation area, forms part of the area of the municipal corporation. But so far that revenue record is concerned, these are still maintained by the revenue authority Tahsildar.
But the difficulty is, suppose if somebody are submitted a plan for sanction, he
Yes.
wanted to make a construction. Then unless the municipal corporation has, whether he is the owner who is submitting a plan, whether there is any
Yes,
of that,
Yes.
how? So they call for
May-
records.
I will clarify that. I'll clarify that. What is happening there?
More cumbersome situation.
Holding.
And in the municipal
Plot numbers
corporation.
maintained by development authority.
No.
Plot
Plot numbers
plot
are being
number
maintained by the revenue authority. It's Potta, what here in this case is called record of right of Potta. A copy
Patta, I
of
know.
Potta, means that
Patta is a settlement by the government in favor of a person.
person.
No difficulty.
That record of right, a copy of postal record of right will be retained with the municipal corporation. While according permission, they have to find out who is the owner of that particular plot, all these things. But
And
so far,
suppose if the mutation is subsequently made, then what is with the mutation?
the mutation matter, so far suppose the land is being sold,
No, there is a devolve. It was in the name of my father.
Father.
And after he departed, I
Yes.
wanted.
Okay, all these are my, here in
Substituted.
this case, all these mutations are being done under Mutation Manual and Survey and Settlement Act by Tahsildar.
By the Tahsildar.
By Tahsildar. Here are two authorities.
Two authorities.
Two authorities. And the most
Overlapping part.
overlapping parts.
In favor of the legal heir.
The even minutes,
Where is the concept of this word legal comes? Can there be an illegal heirs? Then you use the term legal heirs.
the heirs and
The
heirs.
heirs who are
All
heirs,
under
there
legal
can't be a legal and illegal heirs.
Yes, they are only.
Heirs are heirs under the law.
But our legal miscellaneous certificate rule says legal heir certificate.
I do not know from where this word, I have also seen in many
Sometimes-
legal heirs.
Legal
I say, what is the concern? Heirs connotes that he is.
They are the illegal.
These certificates were issued but as per the affidavit submitted by the applicant. Even if that person's name I will submit on affidavit, my sister is so also legal heir will be issued.
What legal heir?
But this is called legal heir.
Yes.
Class one heirs or a class two
Class,
heirs.
yes.
Has to be, they are heirs, recognized under the law.
There is category of legal heir, who are
That's
the
all.
class one.
That's why the word, the legitimate child and illegitimate
Legitimate
child are used, not heir.
Like this. Lordship is correct.
Heir is, both have a right to inherit.
That's a very choosy about the
Lordship is very deeply.
So that's, that of course, that is the nicety of that civil law.
No, but I mean, really, you're not.
That's nicety of that civil
This is
law.
also the position here, same thing.
But any matters in so far.
What is there, sir? What's that? You don't stand anywhere.
I'm not at all standing. That's
Sorry.
it. That's it.
Is no longer Gram Panchayat or something of that kind. If it has come within that parameter, you can't say.
That's it.
That's all.
My last submission is let them clean to the original modified plan.
Who are you to compel them? Who are?
Because there is
Are you an expert? There must be something.
let them realign.
If there is an encroachment, they have already said that they will follow the procedure for removal of encroachment. If the
I'm not
encroacher
standing.
has,
I'm not standing.
if this encroacher has acquired any legally enforceable rights by virtue of any act, they will definitely take recourse to that. There's no difficulty.
That's it. The present realignment which is under challenge in my read
I
application.
don't think so. They have followed all section 14 and all, everything is followed.
No. For the recent realignment, they have not followed.
That is the recent, that is of 2018 alignment.
23.
That's it, 23. I will record that there is no realignment in 2023. It is a realignment which was done in 2017, duly notified in the official gazette in 2018. What more?
If
From where you got the notion that 23 the
if
realignment?
that is so, let's say I have no
That's
case.
all. And if they have to make a realignment again,
If that
then
is
they will
so,
follow all the procedures which are required under the law. As they followed earlier,
if that is so,
provided
let's say I
there
have
is
no
no
case.
change in the law. Yes, we will record all the facts. So, public.
Next.
You know, or others are next Monday. I will just. So, those facts are also required to be. There is no realignment in 2023.
No.
That is what our officials have told us.
No, there is no alignment.
And the new government has also approve the realignment that was there in 2017.
What is that? That will take it once.
This is water rectification or waiting off, nothing more than that. They have not changed it. So understanding the land management, correct?
100%. But for better understanding, but I have opened the document, that is the road alignment, RTI.
Not, it will even the encouragement to the petitioners to argue more.
Even the copy last counter copy
No
of the
problem.
solved.
Give him for some good purpose for his record.
Well, copy of counter.
Item number 2.
I don't know who maybe formatted to be internal and liberty may be given so that I will find better use.
No. Item number 3.
Well, at item number 3, I have certain facts into the petition. In the course of the day, I will file an amendment petition. There are certain important facts missing in the. No, madam.
Notices have not been issued.
Notice is not issued. The affidavit
You
part.
ask for an adjournment to make further preparation. Have you prepared fully?
Alright, I consulted senior advocate and I have got everything prepared. As per his advice, some amendments are necessary. So,
Give a copy of the amendment.
in the course of the day, I will submit.
You are not in the.
No, not filed. Not filed, it is ready, except affidavit, everything. 1 week time, my lord, time.
Item number 4.
May I please, your lordship. PIL and opposing.
Whereas eviction, you wanted everybody to go now. What do you have to do?
No, the encroacher is a retired government servant and also a pension holder. Under the law, he is not entitled for allotment of any government land. And also more also, in the same village, his son is having another land. And this,
So, sir, you wanted him to be uprooted from there. This was motive.
no, here,
Here, paid for opposite parties, collector who directed for eviction of the encroachment made by the. That means you wanted him to be uprooted.
yes.
I
Here,
believe, but I've used that.
My humble submission is that but see, let's see the petitioner is one person. And at base 27 that is in ODI, the whole endeavor is of the petitioner is that This opposite party number 5, he is encroaching upon the pathway of the petitioner. The first paragraph is stated.
that is a gochur land, objectionable land, that cannot be encroached upon. My lord, may kind of to paste
And that
that.
is also enforcement proceeding is pending.
No,
Now the endeavor is
no, no, eviction has already, order has been passed since 2014. My lord, I have approved the sub-collector as well as the collector, as well as the government. My lord, no decision has been.
Petition.
I will appreciate this submission and I will record. If you say I will recording your submission. That if order for eviction is passed, unless a litigant approaches the red court, seek an order, the order of the order passed by the authority cannot be.
No, not.
I will record and then say what is the law. I record this submission.
Absolutely.
What you say.
That is not right.
They should approve the High Court.
That proceeding is pending since 2013 as per their abomination.
Sir, he says that the order of removal or eviction has already been passed in 2014, if I correct.
Yes, yes.
Now it says that 11 years have elapsed. You have not
Well, actually,
steps for implementation of your order. If it is an ordinary degree, then the penal limitation is 12 years, going to expire very soon.
they have stated in their petition that form of eviction notice was issued, my lord. And I have to take instruction.
Page 30, 31 and 32. And these are the orders passed by the authority.
Where is the?
Page 30, my lord, may kindly see.
I am not aware of.
I'll file the next
I said,
action.
yes, narrated correctly that what you have said in your representation.
Yes.
You want that, environment consideration.
Yes.
In connection with construction case number 0 so that you can have access to your.
My house, everybody can use that.
Your
Yes.
representation to the.
Yes.
Now, where is the order for the eviction?
Page 30, my lord, may kindly see.
30.
Yes, ma'am. This is an order passed by the Tahsildar directing,
What is this? Non-compliance?
because
Nothing, where is the order of eviction?
that is reflected in this order. In my lord, page 30, this record is taken up today. No report has been received from the RI Uddola regarding action taken on the order dated 12/8/2014. And this is the order of eviction.
Where is that?
Well, I
Yes, I think that we have to have a clean.
Yes, this is the reminder to the field officials to take action. Then page 32, my lord, meetings. Revenue inspector said that please provide necessary police protection so that I can take up the eviction process.
What is this implementation?
Page 32, my lord, may kindly see. This is a request by the revenue inspector to the Tahsildar to kindly provide necessary police protection so that I can carry out the eviction.
My lord, page 33 and 34, my lord. They have written for deployment of local police and for magistrate.
Why? The blue-eyed boy, the very influential.
Now I have to take instruction.
Very influential person that you required so much of police assistance, otherwise you cannot enter. I think according to him, he is a reputed, he was in good reputed service, high ranking official.
No, because of political affluence.
What he is, you
He
say.
is a retired government sir, teacher.
Teacher. I just want.
Taken up any other day, my lord. I have sought for instruction. Please honor.
Nothing instruction. No. Is a absolutely an open and shut. You have passed an order for eviction back in the year 2014, 11 years. Now we are really heading for 12th of August, nearly 11 years. Still time. Have they gone for an appeal against that order? Is there any order of stay?
Well, that on
I
that
think
point,
we are saying that if there is no order of stay, they have to go and implement.
yes, my lord, if that's going to
And we are not going to allow your prayer for giving you a pathway. Not supposed to go subsequently. The petitioner approves the authority.
At least.
Yes, sir.
Should be IH. So the dues are means is IH.
Main matter.
Main matter is your lordship that is the advertisement was published on the Mr. One.
This is the, why the directions have not been given to the collector Khordha and Tehsildar Palipatna not to allow the visit party member to operate this query in contribution to the rules.
Now this is staying with you personally.
It is now transferred to the mining officer
Yes, it is.
after the amendment has been made.
And I am making that mining officer as party member. I have filed the IA. IA number 11,934 of 2025. Option to the direction of the lordship. Then I have to amend it.
Amendment is also to be brought.
You lordship may
You
take
can achieve twin purpose both of amendment as well as the addition. It's so difficult.
So I have made, I have filed that I am for implementation, for inclusion, but I have not filed that amendment in respect of. Then man, I have got, then man.
There's some portion of the.
Yes, yes, instead of collector and the officer, I have to amend it manner to mining office.
That's one thing. We are it's not part of it. Huh?
Yes.
Yes. Though an application seeking addition.
Monday or next Monday.
Whatever. In course of this week, you find Monday it will come.
Item number 6.
I will draw the lordship attention to page 32, annexure 11.
What you want, sir?
That my, I executed a contract in the year 2013. But due to the
ultimate use, they abruptly stopped the work.
no, the amicable settlement was there because they could not acquire the land, and also the asset alignment was changed from one place to another place. That's why they compromised.
What was changed?
That alignment.
Oh, alignment.
Change. That's why they made a compromise with me, and for that we kindly see.
Where is the compromise?
Kindly see annex of 11.
11.
Yes, that's the letter of the chief construction engineer to the chief engineer. In immediate kind reference to the subject above, it is stated that tender of the above work was awarded to Mr. Saptasai Construction Super Class Contractor. I agreement number so and so, division Jajpur, amounting to 5 crores 7 lakhs so and so. The commencement of the stipulated date of the completion was 16, 12, 2013, 15, and 12, 2015, respectively. The agency has executed only a value of 1 crore 75 lakhs.
Sir, you have said without compensation, that is what it says.
Yes,
The agreement has been occurred.
In
Not claim any compensation.
no, I'm not my lazy.
Says an agreement with the agency is to be closed or without compensation.
In the second paragraph.
For approval.
Yes, for approval, for payment of my legitimate dues, what I have constructed, that is paid to me. That is only.
What, which one?
What I have constructed. And
Oh, you do not want compensation.
No, that is agreement we have already. We have already made agreement that I will not.
Okay. So 125.7 lakhs.
Yes, is due to.
What value, the what value of works you have undertaken? How much they have not paid?
Then not.
How much?
They have not
Full amount.
paid.
Addition on your part, sir. Madam, this is not. This is not expected.
I do not know, your lordship.
You do not know this letter.
But this letter is there, but what payment has been made or not paid, your lordship?
That
You
will
will
make,
make that you will make the payments and will make an adjustment if you have already made the payment. Adjustment
If
we are
it-
permitting you, or in the event the full payment has already been made, then no further payment.
yes, madam.
Oh, bless you.
If any payment agreement, that will be adjusted, no problem.
And if it is, the full amount is paid, then
Pardon?
if full amount is paid,
No, not paid.
If paid.
If paid, if any amount is paid, that will be deducted.
full amount also.
Yeah, also, no problem.
Okay. This one's in the month of January. Right.
Honest of 12 years, last period shows.
So we will say that within 3 weeks, they will make the payments. In the event they do not, then the interest will be charged, otherwise no interest, because we will agree that.
Yes, right, 12% interest I have.
We are giving them a time, let's make the payments within 3 weeks. If they make the payments, then no interest. If they fail to make the payment within 3 weeks, then we will say that you are entitled to an interest.
Yes. 12% interest.
Why?
Because I have obtained the loan from the bank. For that,
What is the prime lending rate?
whatever you lot like.
At what rate?
That the rate your lordship.
And
Let's say prime lending rate. RBI always fixes.
Yes.
Maybe 18.
your lordship 6%.
There. It's the same. Since 2022. They are not paying 3 years.
Yes.
What do you wish to pay? This interest.
Lordship,
In
3
case of
weeks would
failure.
be around 6 weeks, your lordship, within 6 weeks or 6% interest. No, 6 weeks, no interest. Beyond that,
6 weeks is. This matter is waiting there. And you have admitted, yes, he has done a what?
yes, lordship, but
What 125.7 lakhs. Will you not make the payment?
what?
There is a clear admission.
Yes, lordship, what has been paid, why, if at all any.
Had it been a civil suit, then on under order 12 rule 6, there will be a judgment on admission against you. With interest. At least from January. When you admitted. We will say 6% for this period from January 2025. And if you do not make the payments within 6 weeks, then it will be a prime lending rate of the RBI.
After 6 weeks, 6%, not from January. No.
We are in July. Your admission was there. You ought to have raised the payments. Yes, come. Uh, the consensus was arrived.
Because I have completed the work which is.
Once this matter has been debated before Lordship, which fact? It is a matter where the petitioner is the successful bidder, single one. And his bid has been plus rejected by Annexure 1 on the ground that I failed to attend for trial of agreement within the prescribed time period. I permit to read Annexure 1, S21.
May pattern close.
But I'm appearing on instruction, I'm going to appear on behalf of this number 6.
You are
The second has.
Successful. You are successful.
L2.
No. Second has bid. Second has.
what is this draw of agreement within the prescribed? You could not
Yes.
secure your presence to.
Yes, that is the reason.
Agreement.
Yes. That's the reason
Have you implemented?
the approved tender for the above work has been cancelled because you were failed to attend for trial of agreement within the prescribed time period, neither in person nor through your authorized representative.
Means that
Yes.
you will have to control the authorities for an execution of proper agreement. Is it?
Plus, here knows what has happened.
Or I am
But
not,
not-
so because the facial expression says that you are not satisfied with this.
No, the second satisfy also. Here knows to show favor.
So what was the time within which you were called upon to execute?
7 days. Loss.
7 days.
7 days. Annexure 6.
Did you approach or written a letter showing your difficulty in attending on a particular day?
Plus, yes, I have given letter.
Where is that letter? This was the letter dated 21/2/2025.
Plus, I have given a letter on 27/3/2025.
22nd,
27/3 at Annexure 11.
7th, 3rd.
Third plus.
Third means March.
March plus. And
More than a month.
and prior to that, on 11th March plus, I have given a letter
No, beyond 7 days.
to
Beyond the
furnish.
7 days.
Yes.
Beyond the 7 days.
Beyond 7 days. My humble.
Asking you a simple question, within 7 days, have you intimated that what is the difficulty by identity?
Plus, why 7 days has been given here? Plus, only to debar me from the process.
No, sir.
Plus, I'm coming, plus. I'm coming, plus. I'm coming. Your hospital is seamless. I have been found to be successful.
Well, there is no dispute that you were the L1.
Yes,
You were supposed to execute an agreement. They gave you a time within which you should come and execute the agreement. You could not come. They cannot wait for you, send you a further invitation card to come.
Then that is the long loss. Yes.
Correct. Now, as if that there may be some competing circumstances where you cannot go. There is a competing circumstance. You have to intimate the authorities. You have given me 7 days time. These are the problems. Please extend the time for another 10 days. I will come and execute.
No, there was verbal communications was going on between the
You
authorities.
said so, you are improving your case. Can you show me from a pleading that you have stated that? Towards. I have been noticing here
Yes.
that the case are being improved at the bar.
No, no,
Towards from the.
let me explain. Let me
Towards
explain.
from the pleading.
Let me
You
explain.
have stated on oath that you have verbally communicated. Sure.
Understood.
Please. From your written. Anywhere you have said. With paragraph.
Because I'm ready for paragraph 14.
14.
Yes, 14.
Yes. Yes, sir. Yes. Clause upon acceptance of the tender shall within 10 days from the date of the.
Yes, yes, that is in dictation, 10 days time has been provided.
Sir, they have given you 7 days time. I am asking you that extended within 3 days, you have communicated or went there. Where is that?
Plus, my argument for Lordship, for a moment, for Lordship's kind appreciation, for a moment, plus. Would you acknowledge? Because they have given me 7 days, and out of the 7 days, when the letter, of acceptance has been issued under Annex 6, that is actually 76, because that is immediately thereafter 2 days holidays. Then 2 days holidays, only 4 days, because they have given 4 working days to me. So within 4 working days, whether it is humanly possible to drop.
I appreciate, sir,
Yes.
where you have said that when you received this letter on 21/2.
Plus on 21st February, on 20.
On 21st February.
Yes, please.
1.15 of DPCL talks about 10 days time.
Yes.
If they are given a shorter time, so no difficulty, but you show me that from 21/2, within 10 days.
Yes, 10 days, if it is 10 days loss,
You have approached the.
it is 10 days, it is coming to 6th loss. It's 6th March. Because it will start from 22nd, 20.
I do not think so. This was this year or?
Plus, with the
No,
application,
it's not a leap year.
with the application of general clauses.
CA, so when we start 7 days, it will end on 3rd March.
7 days loss. But if it is 10 days,
10 days.
10 days it is 6 months loss. Because 5th is a holiday.
Third.
Plus with the application of general,
No.
plus I am
Application of the day does not mean you will exclude the holidays.
no,
10 working days, it does not talk about.
plus one initial,
It talks about 10 days. It does not talk about the 10
then it is 5th,
days.
then it is 5th loss. 5th is a holiday, that is the reason why it is 6th.
Calculate, my mathematics may be wrong.
Look.
21st.
Yeah.
21st,
22nd, 23rd.
24, 25, 26, 27, 28, 8 days. It will 1st March and the 2nd March. I can exclude 21st, then 3rd March,
Madam,
10 days.
28th is the 7 days.
So third
Then
March
1,
is-
2, 3.
3rd March is the last date, 10 days.
Plus, what is my humble son people lordship with the application of general clauses act, plus with the, of course, with
There
the
was the clauses like what?
paragraph,
Month
section
or
10,
days is divided.
section 10, section 10. Competition of time. I'm back by judgment of the Honorable Apex Court also, whereby any central act or regulation made after the commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office on a certain day or within a prescribed period, then if the court is closed on that, office is closed on that day or the last day of the prescribed period, the act.
Please read all the judgments. I will be happy if you can cite a judgment.
Yes, boss.
It says, when a period expires during a time when the office was closed or a court was closed, then on the first reopening day, when the office reopens or the court opens, if you take an action, that would be within the period of.
Well, there are two parts now. From the
If even for.
well, there are two parts.
The Saturday.
Plus on 21st, plus on 21st, letter of for a moment, the letter of acceptance has been issued on 21st. On 22nd, 23rd, there are holidays. So from 24th plus, the time is to be computed.
No,
No, you also can see the.
no, it can never be, no judgment, I believe, can come to this, show me. Show me,
A short judgment.
please, show me.
Will also can come to paragraph 5.
Yes, please.
What is stipulated in clause 4 of the letter dated 30/10/2001 is a communication regarding refusal to accept the allotment. This was done on 28/11/2001. Respondent 1 cannot put to loss for the closure of the office of Huda on 1/12/2001 and 2/12/2001 and the postal holidays on 30th/11/2001.
Sir,
In fact-
I am again saying you are relying on this judgment. Please tell me that this judgment speaks the manner in which you have interpreted.
Plus here plus
Please.
that particular judgment at page
Please
193.
show me the manner in which you have done.
Because here, this judgment part of that paragraph 5 plus speaks about two maxims plus two principles. That is plus the law doesn't compel a man to do the impossible. That is less non-cogit and impossible here. In that case, plus here 4 days have been given to this person to.
Please do not segregate the judgments.
No.
You have to read the judgment in its proper perspective.
No.
And in the context of in facts which is used there.
I know.
It was a case where the issuance of the notice, there were a closure of the office for a particular day.
Well,
The court says that you ought to have come on the first day when it reopens.
yes.
Because the impossibility to do a thing when the office is closed, that cannot be act as a detrimental to your interests. And again, you are excluding certain days. What you are doing is in computing the period, you are excluding Saturday and Sunday, which is coming in the meantime.
No, not Saturday, Sunday. Saturday, Sunday, because those are holidays. Because there are other. Because that is one aspect. Because that.
And we, what is illogical.
Because that is one aspect. That is one aspect. The other aspect also.
I have abandoned this one.
No, plus here in this point, what has happened, the other aspect also, that is because the act of court should. Last time your lordship has put a query to me regarding the discretion of the authorities.
What?
Regarding whether he has got the discretion to extend or not. Because here, I am taking your lordship to that point.
Extension is permissible provided there is mitigating circumstances. I just asked you a question that within changes which you have approached the author and asked for extension of time.
Well, I have approached on 11th.
Close the results, like what prevented you not to come within time.
Because I have.
We can then definitely appreciate that yes, there must be a human approach. There should not be so much of technical approach. Here it appears that you did not do anything.
Well, that has happened, plus. I have applied on 24th, plus. I do it
That was in June, March.
no, on 24th February, because on 21st, plus.
You know that on 24th February you applied. Within 3 days of the receipt, these was, if I'm asking you.
Because that document, of course, has not been annexed, but that is with me. That has not been annexed.
Is there any pleading you have made?
No,
Please
that
tell
pleading-
me any pleading is made.
That you also can peruse this document.
Why we will
That has not been filed, of course, plus.
not file. I am again saying non-filing of a document is one thing. And a pleading of that document
Yes.
is there is another.
Yes.
Sure that you have pleaded, we will permit you to take that document, provided it's pleaded. Show us the pleading that you have pleaded.
Plus. Meeting is available, yes, plus.
We are inviting you, sir. Very patiently inviting you. Show us any line, above sentence which would say that you have approached.
No, paragraph 8 only I have said, it has been stated in that case. 8, because paragraph 7 says about the letter dated 21st February, the letter of acceptance. Then plus paragraph 8 plus, that is 11th March 2025, where I have asked for the IFSC code.
So beyond 7 days or a 10.
Beyond 7 days or 10 days, beyond 10 days plus.
So
Beyond 10 days.
what do you expect?
But plus now, because of the first 2 days holidays plus, I have applied it plus, that I can bring it on record plus. That I have applied on 24th plus. And bank guarantee is a cumbersome process that is to be issued in favor of the applicant. And what has happened was here, bank guarantee has been issued and also has been accepted by the state authorities, opposite parties. For a moment, also can come to, because here the tender has been finalized on 18th November 2024. 18th November 2024. Then 180 days extension on the 18/11, that is at page 72. Where I have declared as the lowest bidder. Annex 4.
But this letter was issued on 21st of February.
Plus,
2025.
then two
What you are
extension
talking
plus.
Talking about this.
Plus, my humble service is plus what I want to convey. That is plus two extensions, each being 90 days. So 180 days, 6 months have been plus extended tender period. Then plus I have
These are
received.
all over.
Yeah.
Sir, these are all over. They have simply extended the last date for
Man.
submission of a bid.
Man.
Or they may have extended the date for opening of the bid.
Man.
Whatever be, these
Man.
are all the past.
But thereafter,
Only thing is, we are concerned that your action after 21st February 2025.
the only letter I have given was on 11th March 2025, that is Annexure 7, 11th March. There I have asked for, IFSC code. And later when they could not provide me, I ascertained the IFSC code. On 13 plus I have prepared the bank guarantee that has been deposited. And for a moment plus, logically I'll come to Annexure 8. The bank guarantee has been issued in favor of the Superintendent Engineer RAMAN division. And in the midst clause it has been written, please note. Has already started. Well, this period virtually has been 12, Annexure 12 page 92. Where the Superintendent Engineer, I will come to sorry. I will come.
Period.
That is Annexure 10.
22/5/2000. You're referring to Annexure 12.
Annexure 10, sorry, please. Annexure 10. I will come.
That also
26th March 2025. May I be permitted to read this letter? In inviting a kind reference to the subject cited.
Hearing them come to the third paragraph.
In inviting a kind reference to the subject cited above, it is to state that the above work was approved and accepted in favor of the first lowest tender of Messrs. DK Engineering and Construction. Special contractor has come. This is a petition of us by your good office letter under reference. It has been addressed to the Chief Construction Engineer. A letter was issued to the agency for drawal of agreement by this office letter number 1098 dated 21st February 2025. Enclosed for the kind reference. The letter was sent by registered post in the present address as submitted by the agency in his CDMS license number so and so. The same was email also. Many emails here also kindly appreciate. Many attempts were made by this office to contact the agency via phone, but he failed to reply or attend the call. But this is a very vague reply they have given.
Sir, this is your letter. No, this is the office letter.
Yes. It is then after a gap of more than 2 weeks from dated 21st February 2025.
Because we are protecting him over the thing, or he was protecting.
It has superintendent has written to the chief construction engineer. But because it is because a 7 crores the project, there's SC cannot take a decision. It has to be sent to the chief construction engineer. So the reasons in what way that has been assigned. So many attempts are made by this office to contact the agency via phone, but he failed to reply or attend the call. Plus even no phone number, nothing else. In what way they have contacted, only said that this via phone they have contacted. This is absolutely vague loss. After a gap of more than 2 weeks from 21st February 2025, the agency emailed a letter on 11th March 2025 requesting to provide for more time for submission of EMID, ISD, FPSD This was your BG, bank guarantee. As a result of this, a final letter was issued to the agency requesting him to show out the reason of his failure to draw the agreement within the stipulated time allotted to him. This was communicated to the agency by letter dated 18/3/2025, which includes for a kind reference. The letter was sent by registered post in the present address as submitted by the agency in his so. The same was email also. Plus, this is important. Finally, after a gap of nearly 1 month, dated 21st February 2025, an unknown person was, they are saying, an unknown person, other than the person as mentioned in license, visited this office on 20th March 2025 to submit bank guarantee towards APST and IST of the above work. The person didn't present any documents towards his identification and his relationship with the original agency, Mr. DK Engineering and Construction Special Class Contractor. There is no reply submitted explaining the cause of delay in response to the show cause issued by the undersigned. There are no additional original documents submitted here. This line is very important. There are no additional original documents submitted by him as sought during the time of drawal of agreement. You will also kindly appreciate this aspect. During the time of drawal of agreement, that entire period, whatever delay has been, that has been condoned. That has been waived loss. So during the time of drawal of agreement, some documents could not be produced by my representative. In the meantime, L2 bidder of the above work, Sri Rajat Kumar Padi, A-class contractor, submitted his grievance to the undersigned on 10th March 2025. 10th March 2025. Sri Padi has claimed that he should be awarded the work as the L1 bidder who not drawn agreement within the stipulated time allotted. The grievance letter is also enclosed for the kind reference. As of till now, for a moment, this after. As of till now, there has been no further official correspondence between the office of the undersigned and the agency, Mr. DK Engineering and Construction Special Class Contractor. Thus, it is unfortunately understood that the agency is not interested to execute the work. Plus, when I have submitted the bank guarantee to the tune of rupees 1.25 crores, plus I am not interested how plus it is subject to satisfaction of that authority. Thus, it is to return here with the tender for the above work with all revised tender documents in the light of PW2. And then, so on these plus, so SC is a superintendent engineer. Ultimately, final order of cancellation has passed by the chief construction engineer. So I am not interested in loss because of my non-interested. As has been loss, he had satisfied that I could not draw the agreement within the time stipulated time. So it is unfortunately language. It is unfortunately understood that the agency is not interested to execute the work. And basing upon the same, plus my bid has been cancelled. And it is lordship very well knows, it's lordship quite aware about the drawing of bank guarantee. Then it is signing of agreement. It is not possible within a period of 4 days, 7 days, even 10 days. It takes some time. It is both parties work together on that subject. Because only to give a chance to the L2 bidder, only to show favor to L2 bidder, because my tender has been cancelled at the behest of the superintendent engineer. And I have written to the chief construction engineer under Annex 11, page 91. And my writing has not been answered. On 27th March 2025, I have stated very clearly that we have requested via our above referred letter to give some extra time to submit IST and APST and provide us IFS code as required by the bank. On 13th March on 13th March, bank guarantee was issued to us but could not be submitted to the office due to festive season. Last time, Lordship has seen that because there are 2 holidays, that reason why submitted. On 20th March 2025, our representative Nitesh Kumar Jain had attended the office of the SC and submitted the bank guarantee towards IST and APST. Copies of BG are enclosed here for your kind reference. Our representative had visited the site. This is very important. Clause 4. Our representative had visited the site along with the JE, discussed with the other department officers, and requested to intimate us the date when we can execute the agreement as normally it takes a considerable time to complete the verification of securities and other formalities. Now, writing that the contractor is not interested to execute the work is very much surprising on our part. Moreover, intent of the department is not understood at all. Now, we request the good sir to kindly allow us to execute the agreement, start work at the earliest possible date, as we have already submitted required amount of IST and FPST. Please, then I have written to the chief construction on 22nd May 2025. After cancellation of the bid, to reconsider my case. No, sir, only the last operating parameters I am reading. For legal and arbitrary decision by letter dated 15/5/2025 in cancelling our bid and recommend the tender work in favor of the second lowest bidder, we have upon regarding filing of writ petition we have intimated. And request your authority not to issue work order to the L2 bidder during sub judice of the writ petition, and for which you, of your kindness we shall be grateful to you. And none of the letters have been answered. Now, first I have given a letter on 11th March plus to get the IFS code, that has not been answered. I collected the IFC code and I will deposit the bank guarantee. And then also, instead of issuing going for signing of agreement, they stated that they have given a show cause notice. That is at 18th March 2025, Annexure 9. Hence, you have to show cause as to why actions are taken against you as deemed fit as per relevant clause of detention and codal provision. Because before 18th March, plus on 13th March, already the bank guarantee has been deposited. And that has not been questioned. As on date also, that is with the, government functionaries. And for a moment, the discretion of the engineer, that is, I am taking a lordship to the detention. That question called from lordship, how on the last article. Page 42 per moment. Sorry. I'm going through 1.5, 1.6 and 1.8. 1.5 says that upon acceptance of the tender, the successful tenderer shall within a period of 10 days from the date of written intimation of the acceptance of the tender, deposit with the concerned authority sum of such amount towards initial security as would together with the earnest money make 2% of the work. Plus that I have paid. Then was failure to deposit then was failure to deposit the additional amount towards initial security deposit or to sign the contract within the stipulated time, we shall include any extension. This is I am putting emphasis on this part. We shall include any extension granted by the chief construction engineer, RW Circle, Sunabada chief engineer, building and bridges, at his discretion. We will make the earnest money deposit of the tender liable to forfeiture, and acceptance of tender shall be treated as withdrawn. So decision lies with all the engineer who could have extended the time. On 11th March, I have asked for IFS code, that has not been given to me. On 13th March, I have deposited the bank guarantee, and despite the same loss process, they went with the process to cancel my bid and cancel, and they are going to alert, settle the tender in favor of L2. And even another provision is there. One point is the acceptance of the tender and award of the contract even to more than one contract if considered necessary, will list with the chief engineer, building and bridges, rural works, who doesn't bind himself to accept the lowest tender and will reserve to himself the authority to reject any or all of the tenders received without assigning reasons. Because when a discretion is being conferred upon an authority, that should be very fair exercise. Here the question is furnishing a bank guarantee. I have furnished the bank guarantee, and they have accepted it, they have kept it to them, and the junior engineer has gone with me to the site. The site has been verified. Only because the agreement could not be signed due to non-availability of certain documents, plus my tender has been cancelled. And one more judgment I'm citing for the lordship's appreciation. That is relying upon a judgment. There in that case, of course, plus 1 day delay because bank was on strike for 2 days, and before that 2 days holidays are there, and 1 day delay was continued. Then was paragraph 25. There are so many judgments have been discussed. At paragraph, decision-making authorities, like the tendering authority here, could not have turned a blind eye to undisputed ground realities and compelling necessities, like the one that presented itself here. After all, they do not live in ivory towers. And paragraph 26, relying upon a recent judgment of Afghans Interest Limited, their lordships have held. In this case, the tender, paragraph 26, I'm reading those. No, losses past bit of last edition. The tender authority, after due verification about the non-operation of the banks on 15/3/2021 and 16/3/2021, the strike by the bank were accepted the additional corporate security on 17 March 2021 and awarded the work to the appellant. It is well settled by a long line of judgment that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate the requirements and interpret its documents. Next part is that is, it has also been held that the constitutional courts must defer to this understanding and appreciation of tender documents by the employer unless there is malafide or perversity in the understanding or appreciation. And at the last page 35 clause, relying on the judgment that is passed in Jagdish Mandal versus State of Orissa, 2007, volume 14, SCC 547, 517. There the ratio has been decided, where the court can exercise this discretion. Therefore, court before interfering in tendering or contract matters in exercise of powers of judicial review should pose to itself the following questions: whether the process adopted or decision made by the authority is malified or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court can say the decisions that no responsible authority acting reasonably and in accordance with the relevant law would have reached. Plus, I am relying on this portion. And whether public interest is affected. If the answers are in the negative, there should be no interference under Article 226. Plus, my humble submission for Lordship that the authorities have acted unreasonably and arbitrarily and to show undue favor to the L2. And for that reason, Lord, I humbly pray your Lordship to interfere in this matter. At least notice may be issued, let them file their response. Plus only, plus I know.
No, I just, have you finished? Yes, I go.
Plus I have finished. I have finished. And because favor is being shown, that is.
That's why I asked, have you finished or if anything is left? Tell
Plus
us.
one thing, at last, plus I am one thing I am just praying for Lordship. Plus here there is because it is within the discretion of the authorities. Here plus what is the consequence? My entire deposit, private initial deposit will be forfeited and I will be blacklisted for 3 years. And what is my fault for this reason? Plus
You have not paid.
that part may, at
You
least
have not paid.
that means your Lordship.
You have not prayed for. Your prayer is very much restricted to a cancellation.
For a moment, may humbly pray to just to amend it. So because otherwise this person is highly prejudiced. Because even if he is not getting the work, he will be out of the any. To participate in any government contracts. Plus in future for 3 years plus. And for and what is the fault you also can understand. A person should be punished. Proportionally punished. If he has committed a mistake, to that extent only he should be punished. Here the person only made 3-4 days delay in approaching the authority on 11th March 2025, asking for IFSC code. And then he has deposited the amount and bank guarantee has been issued. For that reason, I humbly pray, Lord, that part may be taken care of by Lordship. Because that even in the prayer, that usually is not made, but the prayer is covers that part. And pass any other orders as the some court maintain the stand proper that is there, that can cover plus that, but at least allows me protect my interest to that extent plus my bona fide submission before not within. Plus I have come across a fairly procedure. I have passed through. I became the successful bidder, but only because, and they are saying delivery conversation. I'm saying usually we operate personally, person to person. And by saying in a vague reply, giving that by telephone conversation, I didn't respond. For that reason, my tender has been cancelled. Plus. Only that part, that purity part may can be taken care of. Plus my humble submission for Lordship. The Lordship may allow me to survive at least, not for the even if not for this work, I'm not getting. I know your loss is liberal, but your loss will be little more liberal, at least plus the last period, whatever I am praying for Lordship. In that way, this person can be saved. Loss.
Work order has been issued,
Yes, my lord's agreement has been executed with.
executed.
Yes, my lord.
Work time started since 9/7/2025.
Second There is a perimetry of provision under the Odisha General Clauses Act. See? Just see. It's not. This is a same description. It's a pattern person. Nothing new has been done. Yes. That is still uncertainty in your mind, and a facial expression can be seen. I was late. Two.
I have mentioned the first hour.
Let us proceed. All the matters are so.
Because this is urgent only because admission. Shall I wait?
Item 8.
Is a lordship. Lordship, the encroachment on the Jagannath land, in district of Bhadra. Lordship, first one, the lordship's order on dated 7/7/2023, the lordships are directed for the eviction of the encroachers by the order that was passed by sub-collector on 26/3/2025. Lordship, there has been a subsequent development. The encroachers who were given a notice on 11/7/2025, they had approached the Honorable Court by the WPC number 20153, and they have obtained a stay order in the same.
As submitted everything. Eviction was scheduled to 23rd/7. In the meantime, they have spoken an order.
Whatever has been said that they have approved and obtained the order. Start. We have to maintain the judicial discipline.
That's the issue of paragraph 7.
If he has anything to say, what can be done?
Paragraph 7 of law.
Mentioned in their petition the certificate wherein they should have mentioned that this particular matter is going on before your lordship.
You have to take whatever. We can't suggest you what to take and what not to take. Our attention is drawn to the fact that some of the police who are elected in the
The sub-collector had already passed the order on 26. On 26/25, it was passed for eviction.
I do not know, authority have been directed, their approach has to be made to them.
Lordship,
They have a right to go for appeal.
Lordship, then also there was a notice. They did not
No,
approach.
no, the order says something else. What can we do? Adam, we do not assume the advisory jurisdiction.
Lordship, pursuant to this court's order for eviction, there was a notice sent on 11/7. They have come against that notice. Lordship.
Well, I am seeing there is already a proceeding which is there and the court has said no court will step for eviction against them. What more? Can we pass a contrary order directing the eviction to be done? Can we? Tell me. You are a young lawyer, consider.
I am appealing for the petitioners who are the survivors of the Jagannath
I
land.
appreciate, madam, you have to take now, this is your baby, you have to nurture. The court is not going to tell you what to do and what not to do. The sufficient indication has been given to you. Take whatever steps.
Item 9.
Three matters, madam. One appeal, madam.
Similar matter was pushed on Friday. It was directed to resolve this matter on 5th August.
Well, that to that.
Transport contract.
Item number 10.
Here, the petition is the successful bidder. In respect to particular process, Lordship, which has been completed in view of the rule 27 of the OMMC rule on 16, Lordship, amended rule.
Yes.
Lordship, in this case, Lordship.
Yeah.
Oh, sorry, excuse me.
Challenging two annexures, annexure 6 and annexure 11.
It was 7, sir. That's just to say, between 7 and Lordship.
You are?
I am the Lordship successful bidder, Lordship. But
No, I don't know what. Annexure 6 says
annexure 7 and 11, Lordship.
11, but
11.
your prayer is.
Sorry, it's that little mistake, Lordship.
Then you have to amend. This rule 27(7) of occupancy.
I did not say.
Yes.
Merit.
Yes.
Within 15 days of such intimation, the selected bidder shall be required to convey his acceptance.
Absolutely, I see.
Plus,
Then.
of the terms and
You
conditions.
wanted a 1 month time to be given to you.
In fact, Lordship, kindly see the sequence, Lordship. Lordship, I, under annexure 2, Lordship. May I read, I complete the Lordship, the 27(7), then I'll with the annexure.
So I have already read 27.7 and I have also read 27.9.
Lordship, it is two parts,
Oh,
Lordship.
27.9 also I read.
Lordship, 27.7 is two parts, Lordship. First is Lordship acceptance. Second part is Lordship deposit of the required amount, Lordship.
What has to be done simultaneously?
If notice, then the letter must be in consonance to rule 27.7, Lordship.
What?
But here, Lordship, there is some, here, Lordship, they did not, Lordship, kindly see the
They
come to Lordship.
indicated you.
Lordship. They intimated Lordship on page Lordship, can you say annexure 3. There is a defect in notice, Lordship. Only they told Lordship, only they disclosed in the letter, you are the successful bidder.
Correct.
And in view of the certain provisions, you have to deposit, Lordship.
Correct.
Only they have made copy paste of the provision.
Oh.
Yes, Lordship. Lordship, kindly see the Lordship. Enter provision, they have only made copy paste, Lordship. Though enter 27.7, which is under the rules, Lordship, only they have made copy paste, Lordship. Then Lordship, kindly come to annexure 4. Immediately I have reacted on 13.6, Lordship. I wrote them, Lordship. This is a defect letter.
There.
Lordship.
Sub 6 says that it should be communicated in form air.
Lordship.
They have communicated at page 47 and extra 3 is in form air.
Lordship, kindly come.
Form air.
Lordship,
And therefore, within 15 days of that communication, you
Yes,
have to deposit.
Lordship, kindly come to then annexure 5, 49, Lordship. Because I replied the Lordship, annexure 3 is form F and annexure 4, Lordship, page 48, 13.6. Immediately I replied, yes, I accept the bid, Lordship, but give the amount which I want to deposit, please tell to disclose the amount. Lordship, they disclosed on 16.6, Lordship. Before 2 days left, expire of 15 days, Lordship. That is annexure page 49, Lordship, kindly see. They disclose the amount, that is 1,87,59 lakhs, Lordship. Enter figure they have disclosed page 49, Lordship.
What is the schedule chart?
Schedule chart, Lordship, that is as per the Lordship, as per the rules, Lordship. That is,
That's for 27.7. That's for 27.7.
No, that is the 1.4. I understand. Dr. Writing an additional chart.
That calculation they have given in that
annexure 5, page 49.
5 column.
49 line column they have given.
Yes.
On 16.6, they gave the Lordship, not with the notice. Then, Lordship, on my request, they gave it on 16.6 and granted me 2 days time, Lordship. Lordship, kindly see, they granted me only 2 days. Those statute gives 15 days time, they give 2 days left. Then, Lordship, kindly see, immediately Lordship, then, Lordship, I replied to them, Lordship, this statute requires 15.
1 month.
But, Lordship,
More than
Lordship, it ought to have been 15 days, Lordship. The client has written 1 month, Lordship. But Lordship, prior to that, Lordship, kindly come to Lordship. Annexure 9, Lordship, kindly see. On 26.6, Lordship, I gave the entire consent with Lordship, kindly see annexure 10, that my bank also given certificate. I want to place the amount, please. And they did not respond, Lordship. Despite Lordship, I was reading page 57, Lordship, kindly see. Annexure 9, page 57. On 26, I write to the mining officer. Lordship, may I read, Lordship, that my
no, I have already read.
Lordship. I'm ready to deposit, but he did not pick up my telephone. He did not allow to meet me, Lordship, to him. And Lordship, kindly see the next page is the bank report, Lordship. Bank has given a certificate also. His entire amount is with bank. Please give the dates, Lordship. We want to place the entire amount with the mining officer. Page 58. And Lordship, kindly see, I have brought all the Lordship now. I have downloaded the communication, the way of communications, Lordship, kindly see. Lordship, the postal tracking and communication through mail and through registered post to the AG, Lordship. He has obtained my letters, all of letters, Lordship. He did not attend me, Lordship. He did not pick up my phone. He did not allow to meet him in office, Lordship. He became absconder from office. Only to cancel the bid, he did not permit me to meet him, Lordship, too. I have because Lordship, rule 27 force is my servant. I am servant, Lordship, and I have given a certificate.
27
Roman 4 lordship.
is what?
Because the solvency.
It is your
Because my solvency, because lordship prior.
Solvency.
Lordship, because I don't, lordship, I don't have sort of money, lordship, because it has to be in concerns with the law. They will communicate me and I will deposit the entire amount. And lordship, kindly see 27.7. It is two parts, lordship. Lordship, my humble submission for lordship. This giving consent is the first requirement of law. Immediately I have given consent within days. Then let's say the second part, deposit of money. Let's say if I am depositing the money, they are not ready with the agreement, lordship, it will take another 1 year, 2 years, lordship. So that has been tested and still, lordship, I am giving my consent, I am ready with the money and take my money. And this officer, because to only to cancel the deed. And lordship, rightly read out 27.9 also, lordship. He is not restricted anything. He became, lordship, absent from the office. He intentionally avoided. Now he has come up with this new tender, lordship. And every day I'm following lordship. Every day I'm lordship, kindly I have given the entire dates and sequence events. Every day I'm after him. Only my request as lordship, they granted me 2 days, and I made a request 1 crore 87 lakhs. It will take some process, lordship. It could have been within 7 days, 15 days, and
I'll just ask.
Lordship.
This mechanism, this is the lecture 5.
Lordship.
Was this amount known at the time of offering the bill?
No, lordship. It is up to them to make a calculation, lordship. As per my lordship, price, lordship, they will give this price, lordship. This is not available to the bidders, lordship. This is never available.
Who knows about it?
No, lordship. It is the only up to them, lordship. If they will not figure out this lordship, I can deposit, lordship. It is up to them to come with that mechanism. And that's why I have given the entire tender notice I have annexed, lordship. That is never part of the tender notice. It is only available on the statute, and they will.
Let's do the rule once again.
I'm on the rule.
Yes.
Now, I asked you if this rule. This rule says that you have to comply with the minimum 1/4 of the royalty and extra charges. Can you show me from Form F, or can you show me from any documents that this particular amount which they are supposed to deposit was communicated or made known to you? And there is no difficulty in ascertaining this amount.
Page 37, you feel lordship, my time is. Page 37.
Asking you just this much, you show. Proving that something can be resurrected, ascertained, figure can be arrived immediately on form of. Any model.
Page 37, if your lordship, my time
Please.
Page 37 of the e-auction tender
Please. Clause 9.
clause 9.
Please.
The selected bidder shall be required to convey his acceptance of the terms and the conditions within 15 days of the intimation regarding his selection, and to deposit an amount which shall be calculated in such a way it shall be equivalent to 1/4 of the total amount of royalty and additional charge and amount of contribution payable to the.
Show me that who will calculate. A 1/4 amount is to be calculated. Who will calculate?
It's not there in this record, but I'll have to ascertain from the operations manual.
The difficulty is that if form F does not indicate the quantum, it should. That is not indicated there. Very interesting, I find from form 27(7) has twin obligations on his part.
Yes.
One is communication that he's agreed to enter into the terms and conditions. And second, he will deposit 1/4 of the royalty of the extent.
That is conjunctive.
Both have to be done within 15 days.
Yes.
From the date of the intimation.
Yes.
W6 says intimation in form F. Now he says that showing, give me the amount, show me the amount, calculate the amount, what amount I have to deposit.
Yes, my lord, that I'll answer.
Who will calculate? If there is any clause which says that what should is to calculate the amount, I can understand your case. If the calculation is to be done by you, then unless you communicate the amount, how you will be able to deposit?
I'll answer that, my lord. The lordship may kindly see the date of intimation. That is on 3/6/2025. Much after 10 days, my lord. He makes this.
Sir, it was your obligation that you will serve form F within 3 days. You did not serve. Under sub-rule 7, the period of 15 days will not reckon unless you serve the intimation in form F. If you take 10 days time, then he cannot be blamed for that.
But we didn't take 10 days time.
Yeah.
He rather responded to our letter, that intimation letter after 10 days. That is at Annexure 5, my lord. He responded after 10 days.
P6
Yes,
was the date.
yes,
He said P6 was the date.
my lord.
He communicated within 15 days, he has to communicate.
Yes.
You can't say if he has taken a steps on 14th day, you cannot blame him. Because once the period is provided, in the action is within the period, no difficulty. He took the time within 10 days,
But we also.
conveying his consent. And then say, please give me a calculation, I will make the payments.
But
You communicated it to him on 16.
that is within that 15 days. That is within that 15 days.
6 you communicated.
My lord. Within that 15 days.
And then you say you deposit.
Yes. Then he asked for another 1 month time.
Forget about it, but he wrote within 10 days from the date of the calculation of communication that I am ready with the money. That is on 26/6.
Yes.
That is within 10 days from the date of 16/6.
But 10 days, 16/6, if the lordship may kindly see. P6/2025, the intimation, 15 days completes on 18/6/2025. On 13/6, he makes an application that give us the, we accept the bid, but give us the calculation. Calculation given within 18 on 16/6/2025. So he should have.
Suppose if he gave an intimation that he is agreeing on 15th day,
Money.
you made a calculation, you can't make a calculation immediately. You made a calculation on this, on the
Just 2 days thereafter.
17th day, what you will do? What will happen? You can't blame him that he has approved on 15th day.
You have sent this through your email.
So, my lord, this intimation is not disputed. My lord. My lord.
Six, from both to some of you. What was the mode of conveyance?
Yes, accepting. Have you received, when you received the 16/6?
Lordship, though, I'm not disputing, I have received lordship, but the date I have not disclosed lordship, the date I have not disclosed lordship. Lordship, so then I can ask the lordship. The date I have not disclosed.
We hope that it is by a mail, email.
Email lordship, because lordship, e-auction, so everything is no mail lordship. But we have sent mail and post lordship, both. So.
There must be some rational we are thinking of a test of this, that how is to be interpreted. And the form F must be that you are agreeing to enter into a contract together with the calculation. That you have to.
But even accepting these 10 days, even adding these 10 days up to 26. Yes. It's one more than.
See, 16. Days are.
But
Possibility, example, is still lose one more.
even this benefit of 10 days is also given to the petitioner. Then again, it comes to 28.
All this is specified. Amount was not specified.
But it has been specified.
Second amount was not given to him. Second amount was given to him only on 16th June. Asking him to deposit by 18th June.
By 18th June.
$40,000.
But that I'm saying, my lord, even adding 10 days to his benefit, even adding this delay of 10 days, which was caused because of us in giving him the calculation, even this 10, adding this benefit of 10 days is given to him. Still then, his letter on 17th says that give me 1 month more time so that I can deposit.
But before that, he came forward. Right? Well, you know that is now regular bankruptcy have also confirmed.
Let me take instruction from the authority. Because on 11, if your lordship will see annexure 11, they have issued a fresh tender. Now the previous one must have been cancelled. That cancellation order he has not enclosed.
They have not cancelled, lordship. They have not cancelled, or either they have resorted to any provision of law. State travel lordship, they have come up with, lordship.
Let me ascertain from the authority what has happened.
When you are acting so hurriedly, in some of the cases, you are sitting over those for many years. Here, within 1 month to expire.
Let me just ascertain the facts. My witness has come.
Proceeding so hastily.
Because if he could not deposit within that statutory period, then it has to be offered to the next bidder, whether.
18th of June,
Yes.
auction, 7th of July, 18th to 7th, so fast. And we must conclude that they are moving fast, but one has to think about it.
Because was not received any instruction.
What is the last date?
First lordship, first August, lordship.
As per intimation, the last date was, my lord, the 18th.
Because we have just shown is a particular page where the calculation is to be done. But you have not intimated the calculation.
My lord.
And the moment you gave a calculation. Yes. Okay, suppose according to me, I feel that it is only 1 crore is to be. I will ready with 1 crore in mind, in anticipation that you will give us. Suddenly you give a calculation, oh, it's not 1 crore, it's 2 crore. You deposit immediately. A reasonable time has to be given to somebody to raise on. And it appears that he has the money with him. And the banker says that I find from the banker's letter, he has a fixed deposit to the tune of 2 crores and all. So sufficient money was there, 1 crore 87.
Lordship, allow me to take instruction from the authorities, but
Proceeding is this way is because we have to then interpret it. This, if the calculation is your job, and your exercise, then it will not defeat that purpose. Cannot defeat that purpose.
that form F,
Yes, Form F does not indicate anything.
yes, that is the format prescribed, my lord.
I understand.
Yes.
If it is a format, then you have to do it in a format. You cannot. Whether the advertisement indicates that what should be the quantum?
No, quantum has not been in, only that clause 9, but that clause 9 at page 36.
So if it is no quantum is specified, how can they calculate it that it is 2480 per metric ton if they do not know that how many metric ton I will be lifting or excavating?
And it used to vary, lordship, as per environment clearance. If the amount is reduced, it will be also reduced. If enhanced, then it will be enhanced. After the obtaining environment clearance, the amount also vary, lordship. That's why it is yet to be obtained. If at all lordship a deposit, I can't operate still till the lordship environment clearance achieve. And this district mineral foundation on the annual minimum guaranteed quantity, all are their price, lordship, they have to disclose.
And it minimum guaranteed quantity varies.
Very, lordship, it varies, lordship. If environment clearance it reduces, it will vary, lordship. It enhances, then lordship it also vary. Lordship, there is a two provision of law, lordship. Before obtaining environment clearance, they can also obtain, they can go for action. If at all after obtaining environment clearance, they also go for action. All those cases, it is yet to be environment clearance yet to be obtained. We have to wait till for indefinite period, lordship. If at all we deposit the amount and execute the agreement, then also we can't operate till the environment clearance comes, lordship. It takes 1 year, 2 years, 3 years, lordship. We never operate till it comes. All these are indefinite processes, lordship.
Like that's me week's time so that I can.
What the effect if you don't go because you will be going in this week. If you open the tender on first, go.
Then on Friday, your lordship may take.
So Friday is a first. Then you will open the tender. So that is last date of submission. Or,
In case you want to participate, we should.
well,
Lordship may grant me time till Wednesday. I'll get the instructions from them. Just 2 days.
The 30th. If you come, then it's all right, otherwise it will be still the.
My lordship. My. My.
Item 11. Yes, sir.
Item 14 is regarding your transport fee on mode of flower. Since the fixed to 18th August.
11, sir.
Yes. No, transport fee on mode of flower, lordship's. The lordship's order. And lordship it has been fixed to 18th August. Right.
Item 12.
Lordship, for respondent number 2 and 3, I have instruction to appear for Odisha Mining Corporation, Your Lordship.
Yes. Yes, what is the matter?
This is regarding my lord, sir. The state has filed an appeal against the direction for execution by the ordinary single bench. The decree passed by this. So the issue that was.
Degree was passed
by this honorable court in the company case.
species to law.
No, my lord, it's like liquidation proceeding, right? From the liquidation. Appointee. So officially.
P8 or what is that old provision?
Earlier provision, my lord.
No,
456.
438 or
456, right, with 438 and
so the official liquidator then what is the execution? What is the decree?
decree was in our favor. The
No, in a what was to release some of the property from the
properties to register it in our name.
The auction was held by the official liquidator.
Yes, ma'am. Through this court by the official liquidator, by the company court.
Liquidation.
My lord,
The company liquidation.
but the earlier, my lord, the earlier company was
The assets were sold.
sold, and we were the purchasers, and the decree was passed in our favor. But it
Sale
was
was confirmed.
sale was confirmed, but the registration was or the transfer was not being conveyanced, was not being carried out. So we filed an application that was registered by the state government and the OMC, which later came into the picture. And
Why?
the
Why they registered?
they said that it is beyond the period of limitation because the decree was in 2007 and the proceeding was initiated for the execution in 22. But before the honorable single bench, we have
It was not a civil degree.
no
In the normal suit, it was a confirmation of a sale.
sale. And apart from that, before the honorable single judge also, there has been a lot admission of liability till 2012. So if we calculate 12 years also, as per their calculation, it should be 2024 and we have filed within time. So that was the question asked to them on the last occasion.
The commission cannot divide the, because section 18 is in relation to a debt. It is not
Yeah,
a debt.
not a debt anymore.
Not
No,
a
my
debt.
lord, if I go by
Not a
their
debt.
strict sense, the way they want.
Start from the date of the execution. Anyhow, this is not a degree in that sense.
I have prepared a small
Write-up.
chronology of events. Madam, I have given of this product.
You have the companies for old ones.
Six 34, if your lordship of the Old Companies Act that I have quoted at page 10. The grounds, enforcement of orders of court. 634 of the Companies Act 1956.
The input property or the actual property?
Immovable.
The nature of the execution for execution of a document.
Not the execution application that was filed. It was for the conveyance dates and the recording of the conveyance.
It's a sales certificate is not issued.
No, my lords. That was, here my lord, since it was through the court proceeding, the order was passed.
But the sales certificate is to be issued.
The order was for executing the deed of conveyance. There was no sales certificate which was there.
No, that the sale has to be confirmed. The sales
Confirmed.
certificate has to be issued.
By this honorable court, it has been done, but of course, the order was to that
Where
extent.
is the company there? Old one.
Companies Act 1956.
Yes, it is voted 56.
634 provision, I have quoted one. Your Lordship.
There is the 56. What are the 30?
I have quoted that provision, my lord. Page 10 of that execution appeal. 634. Enforcement of orders of the court. That is under the old act. Says any order made by a court under this act may be enforced in the same manner as a decree made by the court in a suit
pending.
pending there. 634, my lord. Now here, my lord, the company, this proceeding, this company act proceeding was initiated when the interim order passed by the honorable court was on operation, and the order was passed when the interim order pertaining to the self-same land was pending before a coordinate bench and interim order was operating. Now, well, that is one matter. Your lordship will, because the facts are required to be gone into, your lordship.
Then it was a proclamation. Once the proclamation was issued, then in that event, anybody has any objection, they could have come. And these are all done when they have made a public option. The moment no objection came, nothing of that kind has come, then it is the paramount duty of the court to confirm the same. Once the court confirms the same, then you fall back on, because that becomes finally you can't open it. The proclamation proceedings or proclamation actions were all wrong. Those were permitted, those are permissible, but after the sale has been confirmed, costly.
But by that time, the interim order of the coordinate bench was
I'm
off.
asking that the objection ought to have come. Now there is no subsisting interim order now.
But today, there is no subsisting interim order. But your lordship may kindly see.
In one of the
Because-
cases, they have carried out that direction also.
I'll explain that.
Because this court option, then under the companies that the courts really does those in terms of order 20 of the consequences. They have to follow those clauses. The proclamation means they have to make applications inviting this
Objections and claims and everything.
the intending purchasers let them file. You have an opportunity, anybody who is affected, he has an opportunity to go and make an objection. Even if auction is held, thereafter within a time frame, he has the right to make an objection. The period is provided, within 1 month, 2 months, this period is provided, he can go and make an objection. He can also make an objection that this proclamation has been done, possibility or on the tip of the order. That is also provided under the code. He can. That is order 20, rule 89, 90, 91, all these things are there. Once you choose not, and then it is a paramount duty of the court to make the sale absolute or confirmed. It is only when the sale is confirmed, the function of passing the title would come. As I find, it's simply directed to execute. Why? He has to give a certificate.
Even that order could not have been passed because the lordship may just kindly have a glance to this.
Can you reopen? Please, can you reopen?
But lordship may
Please come to order 20, rule 89. Not 90. Please come, order 20, rule 90. The companies are old.
order 21 rule 90. The lordship said pointing out 21 rule 90.
There is the entire sale is to be conducted following the procedure.
Often, when
You are taking section 634.
634 is one, my lordship. Why am
But this is not, I think, there is a rule. Is there any rules? You're right. Start with that because that is what really
Well, managed.
which is the troubles me. If it is an option, then if anybody wants to come and object, that I think the procedure
Has to be
law
during
will
the
come because
process.
Act is silent. Act is silent. Then what procedural law? You are talking about the executability of an order like a degree of a civil court. Then automatically the provision of the deportation procedure gets attracted. So far as the execution part is concerned. That is what then what will happen, execution.
but the execution?
And if the sale is not, that is what I was saying, that if the sale is to be conducted at the execution stage, then unless it is confirmed, it will remain in limbo. Or sale certificate is issued. Now it is a pre-stage of execution.
Yes.
If the sale is conducted, then what will happen?
Because that Company Act proceeding is still pending, man.
What?
This Company Act proceeding.
Company Act proceeding is for liquidations. Now
Yes.
liquidation here, because the company was unable to pay its debt
Yes.
of a, the 500 or 1,000 rupees was the amount. Which was conducted under section 433 or 434. So there's one. Now, first preferential right of the purpose is the employee's structure.
In the secured creditors.
Preference that comes. And the shareholders are the last. For these months. There's the secured creditor. Unsecured creditor comes at the last. Of saying, this is how it has to be. When property is to be sold.
Yes.
The corpus has to be ascertained and then distributed in the fashion of preference.
Yes.
So now once they sell the property and receive the money from them, then it becomes an obligation of the official liquidator to execute the deal in their favor. How can you as a state come into
Because it is state's property, man.
whatever state, the company is a state company.
Company is not the state
Whatever-
company. The
whatever-
land, man, they are claiming the land over which the company was, the previous company was leased out.
So they will have whatever the lease.
The rights of the leaseholder, the original leaseholder.
Unexpired period of lease, they will get it.
But a
They will
lease,
definitely step into the shoes
Shoes
of
of
this,
the original.
nothing more than that.
but the lease was never granted, but that is what is
What
the
are you
case.
talking about? Lease was never granted, then you say the company was a
But
lessee.
that is the whole issue. That is why
What?
I requested my lord to go through this chronology of events, because the lease was never granted.
There, what we do is, that's also permissible under the law. Then we used to invite the government, would you like to buy the property of the government in liquidation? If the state buys the property, then it goes to the state, there is no difficulty.
Well, it is state's property. It was
Sir,
never come.
You have given a lease, and if it is a lease of a longer period, I do not know.
Well, that is the question. State has never given the lease. Well, that is what I am saying, my lord. The lease was never given. It was only given the IDPOL. IDPOL never, the property was never given to the IDPOL for the purpose of lease. Because IDPOL was the authority who is to grant the property for lease for industrial development.
When the winding up proceeding was initiated, it is really a proceeding in name. Finding a proceeding is in red. Everybody, you had the.
They were parties all through, my lords. They were parties all
Did
through.
not raise when the same was, the proclamation was made, when the bids were invited, where you were? If you were there in the proceeding, then how can you? At a later point of time, raise this. Can't do. Can you find out the whole judgments? I think that Calcutta has moved down.
We will, my lords, we'll find.
Finding up, I think in 1922 or 23, Calcutta, there is one judgment on this. I think subsequently there is another judgment. It says that if the parties were there at the time of the sale, then
Later on, they can ask us.
same, then the same. They have not come within the time which I have.
We will. The state's role also, my lord, that has been also decided in a judgment which we had cited before the Honorable Single Judge. That also will place before your lords. Lordships are.
And our
Kind enough to
objection
fix
before
it
the
on,
honorable single judge, while considering,
Why you did not?
but we have, our objection has not at all been considered by the honorable single judge in the execution proceeding. That has absolutely not taken into consideration. By that time, the petitioners, pursuant to the
You
petitioners,
see the objection, whether it is open to you to take such an objection at such a belated stage. But it's a real question.
it
If
was
you
our
lost all
duty.
the avenues provided in the land, can you take that avenue so your right is closed?
Right, because the coordinate bench delivered the judgment in 2019, which was brought to the notice of the honorable single judge in the execution proceeding matter. That has not been taken note of.
What?
That proceeding matter, the
What
judgment,
was that proceeding?
that proceeding matter, two of the persons, they claiming to be the trustee of the original lessee, they approached this honorable court claiming title over the property matter.
The lessee was a company.
Subsequently, my lord, government took over, government gave it to IDCOL, IDCOL gave the lease to the company.
But that is the
It is
case.
not-
It was
it
never
was
given to the
original-
IDCOL.
the
It was
British
never given
owner.
to the
What
IDCOL.
is this seed called?
That is Industrial
Industrial
Development
Development Corporation.
So.
I'm appearing for the 2 and 3. One, earlier it was an independent company. Now it has been merged with
ONC, Orissa Mining Company.
Mining Corporation. And the land acquisition process never happened, my lord.
It was a government company or it was
government
what? Yes?
It's a government holding company, your lordship.
Government of
Is
Orissa.
the subsidiary of anything or it was fully controlled by the government?
The board of director was there, it was a corporation.
It was a corporation fully controlled by the government, was not a
You
subsidiary.
granted a lease to the company.
Your lordship.
What was the duration of the lease?
But I have to seek instruction probably, your lordship, in this matter. What
It was 99 or 999, what?
it was 99 years probably, your lordship. I have to seek an instruction.
99 years. Okay. And the government is saying that it was never given to IDCOL.
This
Says that once those original trusts, those who came from the original owner of the British time, since their writ petition was dismissed, so land goes back to state government, not to IDCOL. That is the government stand. IDCOL, they are now also sidetracking, saying that IDCOL doesn't have the ownership because we had given it to IDCOL and IDCOL had passed on the lease to the third party, the company.
So after all, it's a lease. No. What is? Scotland. You can't coach, you can't
catch hold of
Daniel Mackinac.
There are only.
She's Mr. Daniel Mackinac.
This entire historical background.
Entire background with respect to that property. Because this is how, because the judgment was rendered by that trust,
I
which was.
do not know, but this property at one point of time, now to some riches. He left the country without giving any rent nor disposal. Now we can't say it's an anyway property, definitely it was not the anyway. Now we can say that it is ST to the government, to that extent. But it's still, if it is an abundant property, if it is not, one that nobody is coming and living, then what would you? Then what would happen? That is, the government has to take from where? It cannot be in medio for all time. Property cannot remain in medio.
That property pursuant to the judgment of this honorable court in 2019, property has already been recorded in the name of the state, my lord, subsequently, which is subsequent to the.
The question.
Yes.
But the state has granted a lease to it called.
Not granted, my lord, that is an issue. They had never granted.
It says that it was granted to me.
No, my lord, let them produce any single document, my lord, that is not a lease.
Lordship will file a detailed affidavit in that case.
That he has been given, how can he grant us further sublease to the
Yes, my lord, that is the question. 1981, a land acquisition proceeding was initiated, but that never ended up because of the vigilance cases and because of the documents, manipulation of documents. Your lordship may kindly see 1981.
He is the erstwhile, my lord. Not
Right. So
Yes.
execution proceeding did not end.
No,
Now, till this time, not end.
no, my lord, it never concluded, my lord. It was kept as it is, and never the property was never given to the IDCO.
Then why you are poking your nose into it? If the government does not own the property, then why you are?
But my lord, pursuant to the judgment of this honorable court,
I am asking very inconsistent this time. You are saying it is a government property. You are unable to disclose the genesis of your right. You say that 1981 there was an acquisition proceeding initiated under Act 1 of 1894.
yes,
This never resulted into the final.
yes.
So by virtue of 2013 or 15 Act, it lapsed. Act 1 is no longer there. It's repealed. Now, once it comes, then a section 24(2) says that it cannot remain. So the government by any means cannot claim the ownership. If you cannot claim the ownership, why you are coming in
My lord,
invading or intervening?
my lord, during the acquisition proceeding, it came to the notice because the inquiry was conducted.
The acquisition proceeding does not fructify into a award.
But
Because
during
you say there were a lot of litigations, stay orders or something is there, you could not, then what remains?
But
The
at
follow-
that point of time, it was pointed out that the trustees, those who claim title over the property, those trust deeds were absolutely fake. They were not the trustees at all. But during that acquisition proceeding,
Right,
yes.
so
Now-
what, then what happened? Can you succeed in awarding,
But now,
publishing the award? I'm asking you,
now the
did
question,
you succeed?
but the question is, when once the property has not been given in lease, either to IDCO or the private
By
respondents,
whom?
by the state, my lord.
How state becomes owner? That's the first question. You can understand the states says section 4 notification. Section 6 declaration under Act 1, and then determination of the compensation award by the collector depositing the money. If they raise any objection under Section 18, a reference has to be made to compensation means the court and acquisition court shall have let them determine Section 18 reference. If you have not done anything, Section 24 of the Right to Fair Compensation Act that has come, all this proceeding lapses automatically. And if the proceeding goes, then your acquisition is no longer, then your declaration goes, your notification. Then what do you say? How you assume the right? No, it's not. It's unnecessarily. He's not sure. How the state program this first thing is. I think we have not come to the concept where the state is a trespass. And it's not right by way of adverse position. I think we have not gone to that far.
In fact,
State claiming an adverse positionary right.
the rights of the state has already been decided. I'll
Yes,
produce that.
I am asking you, sir, this is $1 million question. Tell me, how? You are unable to say, you say acquisition, but you cannot say the award was passed. How the property waste into it, because Section 11 or 12 of the Land Acquisition Act, it says that on publication of the award and the deposit, the property would waste to the government. Then the question of wasting comes. Yeah, the Land Acquisition Act of 18 something, or 1894. Yes, I was talking about Section 16 is the award is to be made under Section 11, which is I am asking you, have to make a publish the award under Section 11? Up to that period, it will not waste. It does.
Well, also like, keep it to Monday, I'll answer. Monday, I'll answer that.
Subject to my friends, convenience and your losses, can it be on 6th or 8th?
See, Section 16 says
16.
when a collector has made an award under Section 11, he may take possession under that, means award after making award, which shall thereupon, that after taking that position, waste absolutely in the government free from all encumbrances. So wasting would come only after the award is published under Section 11 and the position is taken by the collector after publishing the award. Till that time, the right has not vested into the government. Section 4, notification, Section 6, declaration, and then Section 5, 5 objections and all everything. Yes, sir.
This is the estate's property money.
My shortcoming because too interactive. Yes.
And this is a ex-ruler estate's property. And now subsequently, whether it has been vested by operation of the Orissa Estate Abolition Act, that I'll explain on Monday.
Then the question of acquisition proceeding does not arise.
Acquisition proceeding happened because of the view that the person,
You can't blow hot and cold at the same.
but that I'll answer on Monday. We'll also make it to Monday. I'll answer.
You can't. But you have to execute. Official equation is there.
But they have not made him a party, but he was a party before the single.
But here the another point is the execution proceeding. Execution petition was filed after 15 years, mine, of the order, mine. That is another issue. At 12 years is the limitation as per 136. The Lordship knows on the Limitation Act. So beyond 12 years, after 3 years from the date of expiry of that 12
Well,
years.
Article 136. Not, even I'm saying, is it a degree of a court? The court, the civil court.
But it is it has to be construed as a degree of a court in terms of
It's the same, not an execution. But it's not a degree. This confirmation of a sale. If it is a confirmation of a sale, then the sales signing is obligation of the court to pass on the terms.
Then the execution petition, they initiated the execution proceeding by filing the execution petition before the Honorable Single Judge.
Execution of an order.
Yes, madam. Even execution of an order, that order passed under the Companies Act. Now, by operation of 634, that provision, if your Lordship would see, that is more or less like a decree that has to be executed more or less like a decree of the civil court. If it is considered to be as a decree of the civil court, the order passed by the single judge, then the period is 12 years. Within 12 years, the execution petition should have been filed. Now, they filed much after, because that 12 years comes to an end in 2019. They filed in 2022. And even there is not a single petition for condonation of delay was also accompanied.
What are you talking about? And there will be a condonation of.
Cannot be, because section 5 is not applicable so far as execution proceedings are concerned.
Why you say section 5?
Because even there was no averment that there was an acknowledgement, and by invoking section 18 of the Limitation Act, this execution petition should have been entertained, but no application, no accompanying application, and only the petition was filed. Well,
Sir, you are before a very difficult person. Application. Application under section 18 of the limitation. Never heard.
because there is
Section 5 application, it's not large.
yes,
Application under section 14, never.
not 14, my lord, 18.
18 is the application, it's an
Eight.
acknowledgement of a debt during the period of the limitation, enhancing the fresh period of limitation.
Yes.
That is what is section 18. Application.
Then, my lord, the only question is whether the execution petition could have been entertained at all in absence.
Now, we should gauge, does it fail? The sale has not been confirmed. I mean, sale certificate is not issued.
Yes.
If it is not issued, then what?
The execution proceeding is itself bad.
It will emanate from there. If the sale certificate is issued, then the function of the execution of a document.
Then itself the execution proceeding is bad. That execution petition which was filed
At best,
premature
at best,
at best.
can't be dismissed.
We are in appeal. We have filed the appeal arising out of that execution.
Why you have not made a option liquidator the fund?
Because they were not parties before the executing court.
Where is the tabular statement?
Sir, Lordship, so see page 16.
Execution.
Of
Where is
this-
the tabular statement?
My lord.
Execution.
See it has been tagged along with this, my lord, this.
Not in the purple book, my lord. Connected.
Come ready to see where are gone.
Man.
Then they are tomorrow.
My lord, I'll be absent. That's why I requested subject to my friend's convenience and your lordship's roster. If it can be on 6th or 8th of August.
6th.
6th.
But very difficult. Please find out. His petition I have a doubt.
Item 17.
This is without more complications, petitioner is being taxed that is allowing the ITC which has been paid. I didn't refuse the price. If petitioner had paid the amount, purchased the goods during the period of August 2019 to November. From the dealer from this. And has paid the IGST of 4,82,531. That purchase, there is no dispute about the regarding the purchase or out of it. It was reflected on the their return of the seller of the DRC1, and it was again reflected in 2A of the DRC of the sale. But now the petitioners, the assessing officer said that he has not filed the payment, made a payment for that in the STRB. We have shown in our books of accounts and filed the returns and accordingly. In that,
How can you make the input tax credit?
Sir, the fault-
Seller has not.
I have discharged my duties, sir. Sir, I have paid the taxes to them. And he has been reflected in the GSTR that too. If he has not paid it, the initiation will be taken against him.
That's true.
So
That was the input tax credit.
that at that time I have taken because it was done STR2. It was mentioned there that yes, I have paid it. If there is no dispute that now I have purchased it. There is no dispute that I have not made a payment.
No, we are not talking about you.
Sir, this
Talking about the person from whom you purchased.
my lord,
You have paid the
he is a registered dealer.
GST. You have paid the amount of GST to him.
Yes.
Now he failed to deposit that particular his obligation of GST. Now you are since you have paid, you are trying to take the input.
No, I have taken that. I have to file my returns that I have received it.
See, you wanted.
That's all right, sir. I paid it.
Now tell us that whether that is permissible.
That is permissible. That is a permissible act.
Was the any judgment?
Sir,
Since
now that I am just telling that if they initiated the proceeding on 73,
74.
then now you have given that they have dropped that 73 and
And similar matters have been there before this court. You want judgment to have an order which is in there. And possibly. So the impossibility of theory, how can I control? Because he is the agent of the government payment. He confirmed.
Are you telling the validity or rights of section 16(2)?
Sir, that has to be interpreted in that way. That is the reason I am saying that my fundamental rights have been denied.
Because of your E.
Yes.
Really?
Moment you achieve. Page 84 for a moment. You cannot do that. I've already referred to. Your lordship suppose the Sankra. Page 84, page 84. That has been passed on to you. Yes, sir, discuss the owners. Page 80. 25 to 25. 90 days, lapses, your lordship. 23 February 20. May, 26th May. 26th May, another May.
June 13th, when that year.
We did parliament.
Then the condemnation period, because
Then continue.
My let's say the what are the judgments I have already quoted some of the judgments before. And here is standard 73 proceeding was started. There are been dropped at the pay to. Has given that.
One of the matters he has taken that particular. So go, it is within the programmable period, we have this,
No, but going there will not help me because I have already asked them to confrontation. They said, no, we will not make a confrontation. They have given that order. In here it is mentioned. And I have given all the judgments and my opinion and actually the evidences. Sir, what can I do? He has said that he has, as a supplier belongs to Andhra Pradesh, we are unable to assess him. Sir, the same similar matters are pending by before your lordship. Sir, many of the cases are pending by Standing Council can say that it is not pending by law.
It is not that matter.
That what matter?
Not constitutional validity of 62C.
What is the?
It is here you want to discharge your own.
Who is challenged?
Standing basis.
So we have said that we will definitely hear out the pirates.
Yes.
Where we have not challenged the
That
violence.
is, I am saying on that basis, the what the judgments which have the courts have been delivered till date, the Calcutta High Court, the High Court of the I am
They
citing.
will go into it.
Sir, this,
Forum.
sir, the appellate forum will not consider it that is we, because we know going to the appellate doesn't because I know it that there will be no justice which can be given by him. Because the first,
That is what that happens.
because, sir,
Then it is more so that it should go to the appellate.
no, sir, I am not showing that because, sir, he will not call the persons which he has refused it. I have asked them that to give it, but the appellate authority will not another said to their official of my land friend. This is also there is number of cases of here in the book.
This is this way I am telling you. It cannot be decided by appellate court. Please kindly try to understand it. If a constitutional validity is essential,
I will have
the constitutional court who will decide. But if the other points which you are taking on that score is there, then it is better to go to the appellate forum. They can decide.
I am telling you. I will sir amend with the sir it can I will again amend please give me power to amend that.
Your lordship, foreign movement page 84, 85, then your lordship will never entertain this matter, your lordship. Even without going to the virus, because what is section 155, the owners, he has never submitted a single document.
He
Page
said he
84,
has submitted every document.
not a single, this is the order, this is the order.
He's saying, no, let them go and.
Now, if my learned friend said that I have not given it, sir, annex 1 and 2, they have mentioned it, whatever I have given it.
Maybe you have included for the first time in the reputation.
No, sir. Before the authority, sir, I am doing that. That is showing in the annex 1.
Very good ground for appeal. That's a.
Sir, my lord, I will amend that portion, sir. We have to file an amendment petition regarding that one.
Appellate 10%. Your lordship 20.
Oh. My view is 20.
Yes. The 10%. Because it is I'm doubly burdened again.
No, my view is that if you bypass a particular forum,
Yes.
then you will have to show more bona fide by paying at 20%.
If my lords want because I have.
So that is what I say.
Again, I have to
Otherwise,
burden this man.
Go and exhaust the remedy
Sir.
before the appellate forum.
It's
better to go to the appellate forum. That would be better.
My lord, the cases are here related with their money. I'll tag with the other
Case of a
cases.
virus,
But I am amending, I will grant me the.
then in that petition has to be filed in a very different way. Virus, then you'll have to say that which portion of the.
That's section which is, money, 16(4) with it. I have to only add that, but all the everything given. There is no condition precedent. I have mentioned that invoking the 74 proceeding, there is no condition precedent.
It will be a new letter. No. What is your matter which you were?
Admission into others to Vidyalaya.
Oh, with that matter,
Item 50.
Item 50.
Yes.
What is this? What is an urgency that it?
The urgency because the
Or even a.
admission is now going to close by lot. They already now the 6 plus.
When it is going to be closed.
They have closed already. They before started closed. Only so far as the 2 seats are lying vacant. But this petition has also
this.
and they also
What this admission process?
And admission
Which on the
process-
other side.
others of the government also.
Who is a
School mass, I know. The only there is a guideline. It is the word of the employee of others.
Is a class 6.
My lord.
There is no competitive examination which is done by them.
No, my lord, competitive, this is the notification, LRCC guideline. The guideline, the petitioners are to apply before the authority. And there will be the committee, screening committee, and the documents will be verified. But the petitioner claiming, this is the word of the employee of the Adarsh Vidyalaya. He is the employee. He is the only the reserving the quota only. There is a collector has to recommend matter. The collector, that is the, he has not recommended the employee, the word of the employee or not, my lord, the orphan. As per the guideline, your lordship see, the guideline, page 24, start at 25, your lordship see. Page 25 guideline. The collector, may I be permitted to read? The collector and district master as the chairman of the management committee can allow 2 seats for class BI only within the total number of 80 students and in the respective category to which.
Why you should be allowed? Why we should issue a mandamus upon?
Because
To recommend only your.
no, my lord,
Your ward.
because no word. He has not recommended any, there is a one of the employee. Only I.
Take a stock of this. If the last number of applications are coming before him, he will decide that
This is
why
not.
your ward should be given us so much of importance
Because guideline.
over the other.
No, my lord, the guideline, your lordship, see the guideline, only 2 seats, it is reserved for the, that is the word of the employee. And there is, the collector has recommended the persons, that is not the word of the employee, only outsider. The word is reserving quota.
That is his conclusion. If somebody appears to be a more deserving, then
This can be more than my lord, because she is the employee and also my lord, your lordship see, that is your lordship, that is the, she has been selected in the your lordship see, page 36, page 36 in the provisional merit list, and the your lordship 3 candidates to, now your lordship see, 36. Page 36, the selection process started and she was the merit list 1, 2, 3 and nobody has, out of 3, nobody has been recommended.
Only the petitioner is the one. Your lordship see.
What petitioner is the one?
The your lordship provisional common merit student appeared in the OAVT for admission to class VI at Odisha Adarsh Vidyalaya, Block Andapur, Keonjhar for the session to OAV employee work. It is specifically stated these three employees are there. Three wards of the employee are there. And out of three, petitioner one. And the collector has not recommended any name, my lord. And the petitioner.
Maybe where is the guideline says that?
Yes,
it should be
yes.
from the employee's ward.
Yes.
The employee's ward.
Yes, guideline your lordship see, page 25. Page 25.
No, if there is a deprivation, we will reopen.
Yes.
We will not. Let us see
Yeah.
the fate of a child. We are more concerned.
Child.
Yes, which one? Where is the rule?
Rule manager page 24. Page 24, 25, your lordship see. Page 25, VI.
And say Roman 6, sir.
Roman 6. Yes, man. Roman 6, man. Roman 6.
VI.
Your lordship see the collector and the
And
district.
how you will denote 100? See. How you will denote 100?
No. Your lordship.
In a Roman numerical?
No.
Because it is C. So how you denote?
Roman 6, my lord. May I permitted read the collector and district magistrate as the chairman of the.
Where?
That is the Roman page 24. The guideline.
24 or 26 you said.
Page 24.
4, yes.
And then
Clause E or F.
Roman 6.
Last exam.
Last line.
Yes, the collector in the district
Master.
magistrate, chairman of the management committee can allow.
2 seats for class VI. 4 Roman class 6. And only within the total number of 80 students and in the respective category to which the children belong for admission into orphan children or priority the ward of the employee of the Odisha Adarsh Vidyalaya in exceptional cases to provide the opportunity to deprived or deserving children. It is mandatory.
These are all oblique or a slash which is used.
Slash.
Out of these three conditions.
Yes. Condition no orphan, no ward. Minor is recommended by the collector.
I am saying third category is also there.
Yes.
In exceptional cases to provide opportunities to deprive deserving children. If there is a deserving children and who has been deprived, then why not become active?
Now, on priority basis, the lordship see.
That is what is the priority basis means what?
This is children, orphan children on priority.
That is only
Slash.
in case of orphan children on priority, but in case of others, it is the discretion which is to be exercised.
Then your lordship come to Roman 12.
Unless you demonstrate that the children who have been recommended are not a deprived or deserving candidates, I can understand that that is his discrimination which is shown.
The Roman 12, your lordship see page 26. Roman 12. Preference will be Roman 12, my lord. There is a preference will be given in admission to the ward of the employee of the OAVs on priority basis.
Correct?
Priority basis. They have to appear in the entrance test as they will be selected against the post of earmarked for respective category.
Respective category.
Yes.
So there is a category of the children of the employees and those who come.
Yes.
They have been allotted. So they have been provided.
Yes.
Must be provided.
But in this case, no, my lord, no word of the employee has been provided. Only except the.
No, I do not. But if they come and say that yes, some of the word of the employee has been given, and if there is 2 or 3
Yes,
seats,
then I have no case. If they will say that if any word of the employee has been given, I have no case. No pilot in this case. Only I have to say, only I am deserving candidate and I have.
Your Lordship may kindly see XI, the previous provision. There is ceiling limit of 5%. 5% of the sanctioned seats.
that is what I am saying. The city limit of 5% reserved for the children of the employees of the state government and the state PSC.
Seats will be covered in this.
This is for them. Here is employees of the school.
Mr. Cox, that is, if at all, the employee has been given priority and given a seat, then he will not insist process.
Sure that how many ward of the employee are admitted to the school? That's not.
That's what from the beginning I was trying to say to your lordship, that since admission has been over, it has got no urgency. 2 days your lordship may grant me, I'll keep the data. That's what I intended to say from the beginning.
2 seats are lying vacant.
We take instruction to.
So it can also for the petitioner were insisting the bench to take. Is in Cuttack school?
No.
It is about 150 kilometers away from this.
Keonjhar. 1 seat. 2 seats are lying vacant.
They have your lordship's kind permission, mission item 30, it can be taken up tomorrow. Tomorrow. But my environmental clearance has been held up because of a pending PIA. And their case is that we have not been permitted to participate. They can make a representation. Similar cases, your lordship, the heard is.
I will not be too intellectual. And will not also listen to the fullest.
No. That does
So
not.
that we can proceed hurriedly.
Let it come tomorrow.
May I, with the lordship's permission, mention item 35?
Item over all the matters.
Playing for 17, my lord.
First hour your lordship told me.
You want an adjournment?
I want.
Give your number, it will not be there.
My lord, item 17, which was I want to withdraw and file the in a proper way.
Item 40.
File and repair in a better.